Good morning, everybody. Happy Monday, and welcome to episode 361 of TCF Live. My name is Dan Soul, and I will guide you on a 3-hour journey through Courtlandia, starting in Michigan with Magistrate Urich.
Yes.
So you understood the court's instruction that you must select from one of 3 options to protect your rights, yes?
Yes.
Thank you, Ms. Hanson. The citation before the court was issued June 22. This year at about 10 minutes of 8 in the evening, you were operating a 2024 Chevrolet red in color southbound Main Street heading near 6th. And at that place and time, you were cited for operating with plates that had expired on March the 14th of 2026. So this is a non-moving 0-point violation of expired plates. You may admit responsibility. You can admit, explain, and display updated registration paperwork, or you can deny responsibility and the court will swear the parties and take your testimony. What do you wish the court to do for you?
I want to admit to responsibility with an explanation, and I have a copy of the new plate.
So you were operating on that date a motor vehicle in the city of Royal with an expired tag, correct?
Yes.
Okay. You have a new registration.
I do. It's right here. Oop.
Move that oh, I'm sorry. Just try to move that over to your left and hold it steady. Say your name.
Lauren Hanson.
Officer Keikos.
Yes, Your Honor. Motion to dismiss the citation.
All right. Thank you for getting that squared away, Miss Hanson. And thank you for coming in. Sorry you had to leg it all the way down here to 11 Mile Road. You have a great day.
Thank you so much.
Only case numbers 26RO04142 and 26RO04142A. These are people versus Mohammed Miha. That's you?
Yes, yes, Your Honor. Good morning.
Good morning, Mr. Miha. You were present earlier today when the court explained the nature of an informal hearing. True?
Yes,
So you understood the court's instruction that you must select from one of 3 options to protect your rights, correct?
correct.
Mr. Miha, the citation before the court was issued on June 12 this year at about 20 minutes of 11 in the evening. You were operating a 2000 Ford Mustang orange in color south of Woodward Avenue, Coolidge Highway. And at that place and time, you were cited for an unsafe start and squealing tires. Officer Keiko's remark on your ticket indicates accelerated quickly from traffic lights, squealed tires. Driver advised he was showing bystander how his vehicle sounds on video. Apparently there was a verbal warning regarding another matter that's not before the court. So the 2 citations are unsafe start and squealing tires. You can in these matters, Mr. Miha, you can admit and explain, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do for you?
So, I just got off work that day, and I just I took the responsibility. Yes,
I understand, and the court appreciates your information, but it has to be within a context. In other words, you have to put that information into one of 2 buckets at this point. You can either admit and then explain, or you can deny, and then the court will take your explanation under oath after the officer. So do you wish to admit responsibility and explain?
Yes.
Okay. Confirming to the court that on the date in question, you did, in fact, commit the civil infractions of squealing tires and unsafe start, correct?
Yes, correct.
Thank you very much. The court accepts your plea. Now, keep going. You just got off work that day.
I just got off work that day, and I told the officer I just washed my car, so my tire was still wet, and it was a stick shift car, manual, so my clutch was wet too. And I was at the light, and there was some bystanders over there. They're saying they want to hear my car to see how it sounds. So I was like just revving it. That's about it. It wasn't my intention to like speed up the car like that. And I think my clutch slipped, and that's why it was making a tire noise like that. And the car and my car is not even that fast. It only has like 200 horsepower. So I don't know what happened. I think the car was wet, and the clutch was wet too.
Okay. The interesting thing, Mr. Mia, about civil infractions is they don't require an intent. The other issue would be if our car's wet, if our car's dry, if our car's covered with snow, if our car's covered with brush, any condition that our vehicle in is solely our responsibility. But the court appreciates your remarks. Officer Keikos, anything you want to share?
I have nothing, Your Honor.
Thank you very much. Stand by, Mr. Mia.
Mm-hmm.
$175 and $130.
Thank you. So, Mr. Mia, the fine
Mhm.
On the squealing tires is $130.
Okay.
With respect to the unsafe start, that fine is normally $175. The court will cut you a break on that, make that one $130 as well. So your total is $260.
Okay.
$260. That is payable through the pay portal on the 44th District Court website, or you can walk cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. That completes your hearing. Good luck to you. Please
Thank
be
you so
safe.
much. Also, like, I don't get any points for that, right?
All the points are the province of the Secretary of State, and there are no points on this one.
Thank you so much. Appreciate it.
Good luck.
Good luck. Thank you. Bye.
It's news to me.
1,000.
This is 26 RO 03616 People versus Kyle Alexander Hoovener. That's you.
Yes, Your Honor.
Mr. Hoovener, your vehicle is stationary, correct?
Yes, the keys are out of the ignition.
Okay, well, you might be surprised. So in any event, Mr. Hoovener, you were present earlier when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights. Yes?
Yes, sir.
Thank you. Mr. Hoovener, the citation before the court was issued on May the 26th this year at about 11:30 in the evening. You are operating a 2006 Dodge red in color, northbound Woodward Avenue Royal, strike that, 11 Mile Road. And at that place and time, it was discovered your vehicle plate had expired on your birthday in April.
Yes, Your Honor.
So this is a simple 0-point non-moving expired plate ticket. You can admit responsibility. You may admit, explain, and display an updated registration, or you can deny responsibility. The court will swear the parties and take testimony. What do you wish the court to do for you?
I'd like to admit and have proof of renewal.
Very well. So you confirm to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Yes, Your Honor.
Okay, let's take a look at that new tag.
I have the paper.
That's perfect. Officer Kakos.
Yes, Your Honor. Motion to dismiss the citation. They've been renewed.
All right, Mr. Hoopner, happy birthday.
Thank you, sir.
You know what to do next
Yes,
day.
Your Honor.
All right, take care.
Have a good one.
Calling case numbers 26 RO 04674, 74A, and 74B. These are people versus Hassan Mohammed Safawi.
Safawi, sir. I hope you can hear me right now.
Safawi, I can hear
Yes,
you.
sir.
Thank you. Mr. Safawi, you were present earlier when the court explained the nature of an informal hearing. True?
Yes, sir.
So you understood the court to instruct that you must select from one of three options to protect your rights, yes?
Yes, Your Honor.
Thank you very much. Sir, the citation before the court was issued July 7 this year. At about 10 minutes of 1 in the morning, you were up in a 2019 Buick, gray in color, northbound Woodward Avenue on 12 Mile Road, near 12 Mile Road, in the city of Royal Oak. And at that place and time, you were cited for speeding minimum of 6 to maximum of 10 miles over. You were cited for not having your seatbelt fastened and changing lanes without signal, which some people find a surprise, but that is a civil infraction. These are just allegations at this time. Sir, Officer Kakos indicates he paced the subject vehicle going 60 plus on M1, changing lanes without signal, wearing no seatbelt. Those are his remarks that show on your ticket. Apparently there is a video capture, but these are allegations. You have three options today. You may admit responsibility, you may admit and explain, or you can deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do for you?
I wish to accept fault with an explanation, Your Honor.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. You exceeded the posted speed by a minimum of 6 miles. You did not have your seatbelt fully fastened and changed lanes without a signal, correct?
Correct.
Thank you. Court is grateful for your honesty. And what do you wish to tell the court, sir?
Well, I believe that, well, to add some context to why I was driving, I had been working Uber Eats for the last 8 hours that day, just what I was doing all summer, just working to pay for tuition. And he caught me at a bad time. It was last order of the day, last couple hours of the day. I just was rushing to get it home. As simple as that. However, the officer was tailgating me for about a quarter mile, lights on, which is why I switched lanes without really putting my signal. I thought it was a crazy driver on the road. So, again, that is my fault. However, I believe that the officer just kind of didn't give me the benefit of the doubt. Um, nothing nothing I haven't seen before, but nothing much I can say after that. So,
Was the vehicle behind you marked? Was it a marked police vehicle?
I couldn't tell. It was dark.
Okay. All right. So I think what you're suggesting is you thought somebody behind you, which turned out to be the officer, was tailgating you and therefore creating a dangerous condition. Is that your statement?
Yes, partially. I simply was just moving out of the car's way. It was rapidly speeding up. I noticed it last second, and I just switched lanes.
Okay.
But creating a dangerous environment, I wouldn't go as far as to say that. No, sir.
The most important thing, when we're operating, a couple tons and a half or less, but with a motor behind it, is to be absolutely mindfully present in that moment. And
Correct.
being tired, sometimes it's better to stay where you are. If you're that tired and you're going to make bad road decisions, ask for a ride, or at least start your motor and sit there for a few minutes, adjust your mirrors, refresh yourself. There's a reason why aircraft sit on the tarmac forever with the engines going, and that's because they're making sure everything is perfect, toot sweet, ready to go, and that they are chipper and paying attention. So with that said, Officer Pecos, what would you wish to share?
Yes, Your Honor, just for context, I was in a fully marked patrol vehicle that night, and I was southbound Woodward, just north of 12 Mile, at that turnaround over there. He was going northbound on Woodward and passed me at a high rate of speed. And I was in a fully marked patrol vehicle, and usually when people see a fully marked patrol vehicle, they slow down. So I got behind the vehicle and I started pacing it, and he was going over the speed limit. And then that's when I observed him changing lanes without signaling. And then obviously the seatbelt too. And I explained to him on the scene that the way he was driving gave me concern of somebody might be under the influence of alcohol just during the time, at the time that he was driving at, and so forth. But other than that, Your Honor, that just for context, for your sake and for him, and I have nothing further to add. And I
Thank you very much.
and I also, just to clarify, I think per my notes, he was issued a ticket, I think, on the same day for speed, and then it got amended to impeding traffic on the citation. Unless my notes are incorrect, but
So you're saying there was a secondary speed from a different officer?
from a different city.
Different city. Okay. All right. Thank you very much for all of that, Officer Keikos. So what the court's going to do, sir, is as follows. The fine for the seatbelt is $65. The fines for the lane change and the speeding are 130 and 135 respectively. The court will reduce each of those to $100 in some recognition of your honesty with respect to how you manage this matter. So your total today is $265. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 14 days. That completes your hearing. Good luck to you.
Can I ask a question, Your Honor?
Yes.
When it comes to the points,
Yeah, the court doesn't have any authority to add or subtract points. And frankly, the judgment is keyed in by this court. The points are the province of Joycelyn Benson. Good luck to you.
thank you, Your Honor.
Good morning once again, everybody. Welcome to TCF Live. A happy Monday to you. I hope you're all enjoying the show so far, but let's change it up a little bit. We'll stay in Michigan, but let's go to Romulus. We'll check in with Judge Oakley.
Kukla and Pettis.
Kukla with a K.
Yes, Judge.
Kukla and Tellis, T-E.
Pettis, P-E-T-T-E-Y-S.
Pettis. Thank you.
Thank you. Good morning.
Good morning. All right, I've got Miss Kukla's file up, so you can start talking.
Good morning, Your Honor. Leslie Knapp, P 34696, appearing on behalf of the defendant, Thea Kukla. Your Honor, will waive the final reading of the complaint and stand mute.
And what are we doing today?
Your Honor, Ms. Kukla is prepared to plead guilty as charged. The prosecutor has offered 771.1 status with 3 months of probation. She is willing to take that offer.
All right, Ms. Kukla, you understand your rights and options today after discussing same with counsel?
Yes, I do.
And do you understand the possible penalty for the checkpoint violation?
Yes, I do.
Understanding all of that, are you pleading guilty to that charge freely and voluntarily today?
Yes, I do.
All right, on June 27, 2026, were you at Metro Airport?
Yes,
Were you at a checkpoint?
yes,
Did you have something there that you were not authorized to have there?
yes,
Was that a stun gun?
yes.
Ms. Knapp, I'm satisfied if you are.
Defense is satisfied, Your Honor.
What should I know before I sentence?
Your Honor, simply that this was a taser or stun gun that Ms. Kukla forgot was in her carry-on. She lives in Saginaw, Michigan. She is disabled due to a neurological disease that is progressive throughout her body. She's 34 years old with no prior criminal history, I might add.
Thank you. Thank you. Ms. Kukla, don't feel that you have to, but this was an opportunity for you to add anything you want me to know that your attorney didn't cover.
She covered everything, sir.
That's why we pay them. I will delay sentence for 3 months. Can you stay out of trouble for 3 months?
Yeah, I plan on it, sir.
All right, that means no new criminal charges, so no crime waves for you. Court costs are assessed in the amount of $350. Can you pay that online within the next 5 days?
Yeah, how much was it, sir?
$350.
I can try, yes.
All right, so get on our website, either pay it within 5 days or set up a plan within 5 days.
Okay,
Got that?
I got that.
Any questions?
No, sir.
Enjoy your day.
Thank you, you too.
Thank you,
Thank
Your
you.
Honor. Good luck, Ms. Kukla.
Thank you. Thank you so much.
I am ready on Petty's, counsel.
Ready, Your Honor. Good morning, Leslie Knapp, P 34696, appearing on behalf of the defendant, Danielle Pettis. Your Honor, we will waive the formal reading and stand mute.
Thank you. What are we going to do for Ms. Pettis?
Same thing, Your Honor. 771.1 with 3 months of probation. Ms. Pettis, of course, has no prior criminal history. This is another mistaken taking a taser through security at the airport.
Thank you. Ms. Pettis, do you understand your rights and options after discussing same with Ms. Knapp?
Yes, yes, sir.
Do you understand the possible penalty for this charge?
Yes,
Understanding all of that, are you pleading guilty today freely and voluntarily?
yes,
Were you at a checkpoint at Metro Airport on July 17 this year?
yes,
And at that time, did you have something in your possession that you were not authorized to have there?
yes,
Was that a stun gun?
yes.
Ms. Knapp, you satisfied?
Defense is satisfied, Your Honor.
I'll accept the plea. Tell me something about your client.
Your Honor, my client is, well, she's going to be 21 years old in a few weeks. She lives in Bowling Green, Ohio. She is attending school for nursing right now. She has no prior criminal history.
Awesome. Happy birthday early, Ms. Pettis. Anything you want to add to that?
Thank you, and no, sir.
Okay. All right. I'll delay sentence for 3 months. That means no new criminal offenses within the next 3 months. Court costs are assessed in the amount of $350. Can you pay that online within 5 days?
Yes, sir.
Any questions?
No.
All right. Have a lovely day.
Thank you so much. You too.
You're welcome
Good
so
luck,
much.
Danielle. Thank you, Your Honor.
You're
you.
welcome.
Judge, next one is McFarland, Kiana McFarland.
Thank you. Appearances for McFarland.
Good morning, Your Honor, and to your staff. May it please His Most Honorable Court, Mohammed Nasser, P74485, appearing on behalf and with Ms. McFarland, who appears via Zoom, consents to the hearing over Zoom. Ms. McFarland, please state your name for the record.
Kiana McFarland.
Good morning, Ms. McFarland. Counsel, what are we doing?
Judge, I spoke to the fine prosecutor. He indicated, and I provided documentation, evidence and saying he said he's dismissing these counts.
Both cases are dismissed.
It's over here.
All All right, I got too many people talking. I'm sorry, Mr. Nasser, we're going to dismiss both counts?
Correct, Judge.
All right. And Ms. McFarland, I'm assuming that's okay with you?
Yes.
All right, you did not post any cash bond, did you?
No.
Cases are dismissed. Enjoy your day.
Thank you.
Have a
You're
good
welcome.
day, Judge. Always a pleasure. Mr. Mena.
Same here,
thank you.
counsel.
Thank you.
Are we ready on Van Buren versus Domas?
I am, Your Honor.
Yeah, that's him.
All right, appearances, counsels.
Good morning, Your Honor.
Oh, sorry.
Good morning, Your Honor. Angela Mannering on behalf of the people.
Ellis Friedman for the petitioner.
All right, looks like Mr. Domas is having trouble unmuting.
Okay, Kevin, try it. Kevin Michael Domas.
Thank you, sir. And what do we got today, counselors?
It's a petition to set aside convictions, clean slate application.
No objection from the people?
Not for the Van Buren case, Your Honor.
There was no objection.
There were two. Yeah, there were two on the application. One was not a Van Buren case, so I can only comment as to the Van Buren.
All right, Mr. Friedman, what's the other one from?
It's a state case already been handled, or a Sumter case already handled August 13th.
So there's already been an order on that one, Heather?
He's never sent in an order. That's what everybody's waiting on.
Yeah.
I think he's going to send it in today.
I'm going to take care of that today, Your Honor.
All right,
And make sure they're
send me an order that
separated,
covers both of
please.
them.
Yeah.
I'm sorry, Heather, go ahead.
He needs to make sure that they're two separate orders for both case,
Yep.
one for each
Got
case.
that, Mr. Friedman?
Got it.
All right, send in your orders. We'll get a signature on them.
Thank you.
Have a
Thank
good
you, Your
day.
Honor.
Mr. Boria, do you need to speak to Mr. Bunch?
No, I informed Mr. Bunch of the offer I was expecting, and it is what I got, so we can go forward.
All right, we're just waiting for your other one. They're checking in right now. So once they're done, I'll bring them in the main session. But right now we can handle Bunch.
Sounds good.
Judge. Mr.
Yep,
Geyer,
I'm
your
ready.
attorney will be in just a minute.
Good morning, Mr. Boria. Your appearance for Mr. Bunch.
Good morning, Judge Oakley. For the record, I am Aaron Boria, and Mr. Bunch is also on the screen. Leon, you need to unmute and state your name.
My name is Leon Bunch.
Thank you. Your Honor, the offer today is that he's going to plead guilty to the checkpoint violation under delay of sentence 771.1. Also with the agreement, once the delay of sentence is completed, I'm being told that he will get the return of his firearm. The prosecutor's not objecting to that. And I understand the fine is roughly $500 and a 3-month delay is what we would be asking for.
What was the agreed upon time frame, counsel?
I asked him for 3 months, and he said he had no problem with that.
Okay. All right. Mr. Bunch, did you discuss your rights and options with Mr. Boria today?
Yes, sir, I did.
You understand all your rights and the options presented?
Yes, sir, I do.
Do you understand the possible penalty for the charge?
Yes, sir, I do.
Understanding all that, are you pleading guilty freely and voluntarily to that charge?
Yes, I am.
All right. On June 24, 2026, were you at Metro Airport?
Yes, I was.
At a checkpoint?
Yes.
And did you have something at the checkpoint that you were not authorized to have there?
Yes, I did.
Was that something a handgun?
Yes, it was.
Mr. Boria, I'm satisfied if you are.
I am.
All right. What should I know before I set terms for Mr. Bunch?
Your Honor, this was an accident. He was leaving the state. He was going to Arizona. He had a bag that he doesn't typically use. Same bag he had used for the shooting range. And he forgot that he placed the gun in there. There's no ill intent here. He's got no prior record. He's got no issues with the airport before. Simply an accident.
Okay. Did Mr. Bunch, did you get the letter from TSA?
Yes, sir, I did.
Just curious, what was the fine amount they hit you with?
$5,000.
Yeah. Mr. Boria, I still haven't figured out how they're setting those because the numbers are all over the board.
Yeah, I don't know either. I had another client get one recently that I think was even higher than that.
Yeah.
I haven't had a client hire me for it yet, but I understand there are like 3 or 4 recourses you can do. You can try to negotiate with them yourselves. You can hire an attorney. You can do an informal. My understanding, Mr. Bunch, if you try to negotiate with them, they'll oftentimes cut that fine in half.
That's my understanding as well.
So probably worth trying.
Sure. Thank you.
Yep. All right, Mr. Bunch, anything you want to add to what Mr. Boria has told me before I set the terms of sentence?
Nothing other than I'm mortified and extremely apologetic for my.
I can imagine it was extremely embarrassing.
Yes.
Yeah. Yep. All right. So can you stay out of trouble for 3 more months? No new crimes?
Absolutely.
I'll delay sentence for 3 months. Fines and costs are assessed at $500. Can you pay that online within the next 5 days?
Yes, I can.
All right. Any questions for myself or Mr. Boria?
I do not.
All right. Enjoy your day.
Thank you.
Counsel, always a pleasure.
Judge, I got one more, so I'm going to sit here patiently.
It'll be a pleasure too.
Leon, you can sign off. He's gone.
What's the name on that one? I'll get the file pulled.
Skip Alice, Avery Skip Alice.
Thank you.
Have you seen those TSA letters on anything other than a handgun?
No, I have not.
Neither have I.
How do you spell Skip Al? Oh, I got it. I got him.
I'm trying to find where I can look, because a lot of these people have the pre-check, and I'm trying to find out where I can check it or have them check if their pre-check is still good. And so far, all the websites I found, because I have a pre-check, when I try to check my own, it says nothing's come up. Are you aware of anything?
I am not.
Okay.
You might check with Jim.
Yeah, he might
Mr.
know.
Mena might have heard something. Yeah. Heather, we got anything else, Roddy?
Justin, are you ready on?
Yes, good morning, Your Honor.
Counsel, who do you got?
I have Mr. Jonathan Geyer and I also have Lucas Green.
Lucas Green, like the color?
Like the color, yes, sir.
All right, I've got Geyer out, so while I look for Green, start talking about Geyer.
All right, good morning, Your Honor, you and your staff. May it please this most honorable court, Justin Andrews, P81445, on behalf of Mr. Jonathan Geyer. We ask this most honorable court to waive a formal readings of my client's, Your Honor.
All right, what are we going to do for Mr. Geyer today?
Yes, Your Honor, after speaking with sister counsel, Mr. Geyer will avail himself to an allowing a licensed person to operate motor vehicle and the DWLS be dismissed.
Thank you. Mr. Geyer, can you hear me all right?
Yes, sir.
Did you discuss your rights and options with Mr. Andrews?
I sure did, sir.
You understood all that good information?
Yes, sir.
You understand the possible penalty for the added charge?
Yes, I do.
Are you pleading guilty to that charge today?
Yes, I am.
Are you doing so freely and voluntarily, sir?
Yes, sir.
Did you drive a vehicle in Van Buren Township on May 5 of this year?
Yes, I did.
Was your license suspended, revoked, or denied at the time?
Yes.
Mr. Andrews, are you satisfied?
Satisfied, Your Honor.
So am I. What should I know about your client before I sentence?
Yes, Your Honor. My client at this time, he was actually attempting to assist his girlfriend who started to look a little bit faint. He took over the wheel of the vehicle and then subsequently he was then pulled over. My client's license was only suspended because he had one more course to complete in Westland for Mothers Against Drunk Driving. He has successfully completed that course and he's in a good position to have his license reinstated. He is going through some other issues legally, but he is also handling those. He is currently in sobriety house in Detroit, remedying any type of issues that he does have, Your Honor. So,
awesome. How many days of sobriety you got, Mr. Geyer?
Well, I'm going on close to 90 days.
Good for you. Good for you. And how's your lady friend health-wise? She all right?
Well, technically, I'm not supposed to be in contact with her.
Okay.
Relationship's over.
Okay. Okay. All right. And time frame, you know what you have to do to get your license restored?
Follow the rules.
Okay, but I mean, why are you suspended? You just got to pay money now?
Well, in Westland, they told me as part of my probation to complete the Mothers Against Drunk Driving in order to get off probation, which I completed that and got off probation a few years ago. But now I believe council was talking about restoration of my license and everything.
Okay.
Could you inform me on what I have to do now to
I
do?
have no idea.
Well,
I've never seen your driving record. I have no idea. Mr. Andrews, do you have any idea what hoops he has to jump through?
So, Your Honor, I gave him several options based on my experience in this area. I told him that either there will be an administrative law hearing with SOS for reinstatement, or there might be fees that might have to be paid to SOS for automatic reinstatement. He was in a restricted state, Your Honor. He pled to impaired in 2004. He was in a restricted state, but he did not complete the terms and conditions of the probation, which I then believe reverted that to the suspension. So now he completed the MADD that covers that last requirement. So it's either going to be an administrative law hearing or it's going to be just some fees that he has to pay for reinstatement. I did suggest for him to, upon a disposition of this matter, to speak to Secretary of State, and they can give him a little bit more direction as to which one of those options
advice
have to deal with.
Good advice. All right, so Mr. Gar, how long are you going to be where you're currently staying?
I've been here almost 60 days. I'm currently not sure just yet. Tending to other legal problems out of the circuit court.
Were you working before you went there?
Yes.
Where did you work?
Burger King.
How long were you at Burger King?
Almost close to a year.
Okay. Is Parkwood a home address?
It's my mom's address.
That's a good mailing address?
Yes, sir.
I'd like to sentence you after I see where you're going with your current program.
Okay.
Heather, we've got a sentencing date in September, right?
Correct.
What is it?
It is September 24th in the afternoon. So we could do like 1:30.
We got MIDC then, I'm assuming.
Yes, we will have MIDC that day.
Okay. All right, Mr. Geyer, we'll send a notice to your mom's address, but write that down, September 24 at 1:30. I want you here live if you're out and about. If you're not, contact us ahead of time, like the week before. Contact us ahead of time and I'll allow you to show up on Zoom. I just want to see where you're at with your recovery program and all your other legal stuff. See what's going on.
Well, my next court date for my other legal stuff is September 8th.
All right, so you'll at least have an idea what's going on there.
Yeah, I'll figure out more on what's going on.
All right, so let's talk September 24th. We'll see where you're at.
Okay, thank you, sir.
Okay, all right, good luck where you're at.
Thank you.
Mr. Geyer, before you leave, just hold tight. I have to get your number, so just hold tight right there. I'm going to take you back to my meeting room in a moment, okay, sir?
Okay.
All right, thank you, sir.
All right, good morning once again, everybody. It is TCF Live on a Monday. I hope your Monday is not Mondaying you too hard yet. And hopefully if it's not, it stays that way. Alrighty, let's go to Florida. Wade Mercer. Let's see how busy they were over the weekend.
Mr. Mr. Long, good morning. You're here for one charge of driving under the influence. Mr. Long, I read the complaint. I've also looked at your criminal history. I'm going to listen to the attorneys and then we'll see where we go from there. Mr. McDaniel.
Your Honor, we just asked the court to, set some kind of reasonable, maybe bond or cash bond if the court's inclined to. He is locally, works here in the area. He essentially, there is some issues with the case too, and the court can take those considerations in as well, as far as, putting him behind the wheel of the vehicle, and some of the issues that may have come up in any DUI case around that issue. We just asked the court to take those things into consideration.
But you're not disputing probable cause as far as I can hear. Is that correct?
I'm not disputing probable cause. I think it's shaky, but I think it's enough in there. I read it, but I think that going forward on the DUI, those will be very problematic.
Thank you, Mr. McDaniel. Mr. Mitchell.
Nothing from the state. Actually, I take that back. We just request that the only condition of his release be that he not possess or consume alcohol. And if he wants to post a cash bond, we're not in opposition to that.
All right, Mr. Neesmith Long, given that, what I'm going to do is set you a cash bond, a cash only bond of $350. The reason it's that amount is because you do have one prior DUI. It appears in Tennessee It's a $350 cash bond. You have a condition not to possess or consume alcohol nor any other substance unless you have a valid prescription for it. So if you have a valid prescription for a medication, that's fine. Take it in compliance with whatever the prescription says, but you cannot consume or possess alcohol at all, and you can not take any medication you don't have a prescription for. I'm going to ask the jail to give you a notice for your court date. Sir, that will be September 28th, I think.
Yes.
September 28th at 9 a.m. They'll give you that notice, and you will get to use the phone in a few minutes, sir, to try to post the bond. Do you have any questions?
No, sir.
Have a good day, sir. Asia Lynch. Ms. Lynch, good morning. Ms. Lynch, you're here because you've been accused of one count of petty theft, ma'am, as well as one count of first-degree misdemeanor trespass. Ms. Lynch, I read the complaint. I've also looked for your criminal history. Ma'am, I'm going to ask that you listen to the attorneys, and we'll see where we go from here. Mr. McDaniel, I was not aware that she does not have an address. That would probably prevent me from accepting the tentative offer that was discussed this morning, unless she has a place to live.
Your Honor, we're just asking, for some kind of reasonable release option.
Okay. Mr. Mitchell.
No.
Ms. Lynch, the complaint lists you as a transient, and what that means is they don't have a verifiable address. Do you have an address that you live at, ma'am?
Oh, yes, sir. I have an address.
Where?
5683 Nubbin Ridge Road.
Okay, and whose home is that? Who owns that property?
It's people that I've been living with for a couple of years now. They're more like family, but they own that property as well. It's a trailer on the property that I stay in. It's actually property that I stay at, but
And how long has it been since you spent the night at that residence?
I've lived there. I'm there every day.
Okay, so what's the answer to my question? How long has it been since you spent the night there?
Well, I don't spend a night there. I live there.
Did you sleep there night before last?
Yes.
That's what he's asking you.
Yes.
Who owns the property?
Who owns it? Betty Grimes.
Okay, so my history shows no prior history, no prior criminal charges. Is that correct, ma'am?
Yes, sir.
Okay, so I don't have a problem with the conditional release. Sarge, if y'all can verify that she has a place to live. I'm not sure why the jail sheet, not the jail sheet, the officer's complaint says she has no residence, and she's saying she does. So if you verify she has a place to live, y'all can talk to someone on the phone that owns the property and verifies that, then I have no problem with the conditional release option. Otherwise, I'm going to set your bond at $2,500 on each count. Your total bond is $5,000 cash or surety. You have a condition to have no contact with any Dollar General, but you certainly could be a conditional release candidate if the jail can speak to someone that verifies you have a place to live there. Otherwise, you're just a bond candidate if you don't have a place to live. Ms. Lynch, I'm going to ask the jail to give you a notice for your court date, which should be September 28th at 9 a.m. Do you have any questions, ma'am?
No questions?
Yes, sir.
All right. Good luck to you, ma'am.
You'll get to use the phone in just a few minutes, ma'am. Have a good day.
What was that bond amount again, Your Honor?
$2,500 each, 2 misdemeanors, 5,000 total. Edward Smith. Mr. Smith, good morning. Mr. Smith, you're here because you have a fugitive warrant from Grady County, Georgia. I know that you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. I'm going to wait till you get through signing that. Mr. McDaniel, I'm assuming that's a waiver of extradition he just signed.
Yes, Your Honor.
So, Mr. Smith, they have 30 days to pick you up starting today. If they don't pick you up within 30 days, you're entitled to be released. We review the cases after 15 days. So if you're still here in 15 days, you'll come back to first appearance. I'll ask the jail where we stand on the transport, and you'll get to hear that answer as well as I do. Do you have any questions, sir?
No, sir.
Have a good day, sir.
All right.
I believe we have our madam interpreter with us. Ma'am, can you see and hear us okay?
Yes, I can, Your Honor.
And it is I'm sorry, my screen keeps changing. Is it Miss Metellus?
Metellus, yes, Your Honor.
Great. Miss Metellus, we have John Jorvalis this morning. I'm understanding as he speaks Haitian Creole. If you would introduce yourself to him, please, and make sure he can hear you, I would appreciate it.
Bonjour, moi c'est Ruth, moi c'est interprète haïtien créole là. Est-ce qu'on m'entendez?
Oui, bonjour, vous m'entendez?
D'accord. I did
What did he
introduce
say?
myself and asked him if he could hear me well, and he said yes, he could.
Thank you. Mr. Gervais, you're here because you were first appeared this weekend on one charge of driving under the influence.
Monsieur Gervais, ou là parce que ou te fait premier apparence ou dans week-end ça parce que ou te a conduit en bas influence alcool ou bien drogue.
You were set a bond by the weekend judge of $1,000, and I've just been told that you posted that bond.
Yo te mette yon caution pour ou même de juge dans week-end là pour $1,000 et yo fait di moi que ou poste caution wa.
The reason you're still in custody is because you have a warrant from the United States Immigration Service.
Raison qui fait ou toujours là dans possession non c'est parce que ou gagne yon mandat qui sorti dans immigration.
I'm going to appoint the public defender's office to represent you for first appearance purposes this morning.
Moi ap appointé yon avocat de la défense pour même pour premier apparence sous la matin. Hein?
And I'm going to ask that you listen to your attorney, Mr. McDaniel.
Et m'a demandé pour capable tendre avocat là, Monsieur McDaniel.
Mr. Gene, there's an offer from the state to resolve this case today. It would account for you spending 30 days in the county jail with 3 days jail credit.
Monsieur Jean gagne offre nan men et commissaire gouvernement pour capable et ba ou tant que déjà servi dans prison qui c'est 3 jours.
If you pleaded that today, this case would be over with and taken care of, and you'd go to ICE to take care of those issues.
Si ou d'accord pour capable plaider gens que yo mandé pour capable joindre résolution, hein, ça va résoudre cas ça et puis yo a relâché ou nan men ICE.
If you do not plead, you would get a court date for you to appear if you're still not in custody or been deported to ICE. Deported.
Si ou pas d'accord, donc on va toujours gagner une date pour tribunal là et que ou va gagner malgré que yo capable relâcher ou nan men ICE.
Are you interested in trying to resolve this today?
Est-ce que ou intéressé pour capable essayer résoudre ça jeudi a?
Là, on dit résultat, par contre, comprendre comment tu détailles des résultats.
When they say resolve, I don't really understand. Give me details on resolve.
30 days in jail, 3 days jail credit, $1,078 in fines, which would be a civil judgment against his credit rating.
Counselor, please repeat.
30 days in the county jail, 3 days jail credit, $1,078 in fines, which would be a civil judgment.
Ça veut dire que vous tap gagné 30 jours dans prison hein, et 3 jours crédit pour tant que vous t'es déjà servi dans prison hein, et $1,078 dans amende.
Ils sont rendus $100 pour me payer.
Répétez.
30 days in jail.
30 jours dans prison.
Combien qu'on peut me payer?
How much money do I have to pay?
30 days in
I'm sorry,
It cut out on you, Mr. McDaniel. It cut out. It couldn't hear your response. The video stopped.
money is, try to explain to him the money is not important.
The video is
yes.
cutting up for me.
Yeah, we're not going to be able to resolve it today. Just tell him that the immigration service will pick him up. We're going to ask the jail to give him a notice.
Nou pa kapab rezoud li jodi a, servis imigrasyon an ap vin chèche ou e yap ba ou yon avi.
Your next court date will be September 28th at 9 a.m.
Lot dat tribunal ou an ap 28 septembre à 9h du matin.
Do you have any questions?
Est-ce que gen aucune question?
Did you say September 28th or would it be the?
You're right. That's the wrong court date. It would be the interpreter court date, which is actually when, Mr. McDaniel?
29th, next day.
September 29th or October 1st. I forget. I think it's 29th.
I stand corrected. Your court date will be September 29th at 9:30 a.m.
Date là à 29 septembre à 9h30 du matin.
Do you have any questions?
Est-ce que gen aucune question?
Ba wè sa ke mga di paske ba konti pou paye pou la chen, ou paye pou ki sa.
Well, I don't see what I can say. I mean, to pay what I pay for them to release me or what?
You have a court date coming up. You need to talk to your attorney in private. We can't do it while we've got a jury waiting to be chosen this morning. Have a good day, sir.
Ou genyen yon avocat ou met pa lavel nan privé, li kapab explike ou. Nou pa kapab fè sa pendant nou gen yon jury présent là. Passez yon bon journée, monsieur.
Thank you, Madam Interpreter.
My pleasure, Your Honor.
We have Brian Nanos. Mr. Nanos, good morning. Mr. Nanos, you're here because you have a first period this weekend on a local charge of resisting an officer without violence and a hold for Holmes County. You're coming back to see if we can resolve the local Jackson County charge. I'm appointing the public defender's office to represent you for first appearance purposes in that case. Please listen to Mr. McDaniel, sir.
Your Honor, I swear to Mr. Nanos, he's going to plead no contest. The charge is listed. The understanding he'll be sentenced to 10 days in county jail, 2 days jail credit, $370 fine, be a civil judgment, and that will resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Nanos, did you hear that agreement?
Yes, sir.
Mr. Nanos, do you have any questions about that agreement?
Yeah.
And sir, is that the plea you would like to enter to resolve this misdemeanor charge?
Yes, sir.
Mr. Nanos, I'm going to accept your plea of no contest to the charge of resisting an officer without violence. I find that it's freely and voluntarily entered with the advice of counsel. I'm going to judge you guilty of that offense, sentence you to 10 days in jail, but you have 2 days credit for the time you've already served. Mr. McDaniel, I did not look and see if the Holmes County hold was a VOP or not. Do we know?
I think it's a child support, $3,000
Okay.
bid. I couldn't find anything else with that bid out there.
Thank you. I'm also imposing court costs and fines of $370. I don't know if I mentioned it, but you have 2 days credit. The $370 will be reduced to a civil judgment if you don't get it worked off at the jail. Mr. Nanos, they're going to notify Holmes County very soon to pick you up. That I don't know if that'll happen today or the next couple of days, but you may actually do the end of this sentence over there. But Mr. Nanos, do wish you the best. Any questions?
No.
Have a good day, sir. Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
Mr. Mitchell from the state?
Not from the state, Your Honor.
And what about from the jail? Anything, Sergeant or Corporal?
No, sir. Yes, sir.
All right, thank you. So I've got a scheduling issue to tell you all about in just a moment. So it's 8.
Alrighty, friends, that brings an end to first appearances for Wade Mercer, but I'm going to keep an eye because he said they had to pick a jury. So we'll keep an eye on that and see what's going on there. But in the meantime, let's go up to Michigan. We'll visit the thumb. This is Judge Prill.
Michigan versus Leon Francis High Scores 267388 FH. Time of day set for sentencing. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by prosecuting attorney Timothy J. Rakowski. On June 1st of this year, the defendant pled guilty to resisting and striking a police officer as well as domestic violence. Ms. Karen Everland prepared a pre-sentence report dated June 29th. Mr. Rooney, if you and your client had the opportunity to review the report. We have. Any additions, deletions, corrections, or objections to the report other than guidelines?
None to those and none to the guidelines.
High scores, do you agree with that?
Yes, sir.
Mr. Rakowski, any objection to the report other than guidelines?
No, Your Honor.
Thank you. Mr. Rooney, what would you like to say on behalf of your client?
Well, Your Honor, my client's 48 years old. He has no prior felonies. He has 2 misdemeanors when he was 19 and 22 years old. Had to do with alcohol and traffic. His guidelines are 0 to 6. I did go over the recommendations with him. Very fair. We're asking you to adopt them. I watched all the video of the interviews and the incident with Chief Naylock. I think the incidents themselves were very minor. The UV was grabbing hold of his wife. The resisting was really failing. He started to walk away. It wasn't put his hands behind his back. It wasn't like he was fighting with the chief. Wasn't the chief at the time, I don't think, but so the incidents themselves were very minor. My client has had some medical issues. He's been diagnosed with a couple of forms of cancer that he's working on treatment right now. So we're hoping that for the next year when he's on probation that some good treatment and some successful treatment for his cancers. Just take care of his dad who lives up in Fort Hope, high scores, lives in Carla Beach. He has been living with the wife almost shortly after this incident happened. Had no problem since. Getting along well. He sees Officer Naylock, they wave, so they're on good terms now. So we're asking you to adopt the recommendation and we wish Mr. Tycois the best with his health and his probation.
Thank you. Sir, is there anything you'd like to say?
Yes, sir. Like Mr. Rudy had said, I had moved in on my wife's request. So as soon as I was allowed to by the courts, everything was put in writing by her to have charges removed and lifted upon her request. The last court date that I had was to have my bond revoked because of lower numbers with the alcohol. I didn't have paperwork at that time to prove that that would have affected my breathalyzers at the time, but I have since then obtained that. And I've spoken with Chief Naylock, was Officer Naylock at the time personally a couple times, and everything's been fine since then.
Do have a question for you though. Do you think you have a problem with alcohol?
I should have handled things the wrong way. Not at the present time. Alcohol is a part of my life. And when I had medical issues, I was drinking, and I shouldn't have used that as a treatment at the time. But I do want to note that when I was drinking at the time, my wife worked out, it was not around.
You understand though, at the time of the incident, your blood alcohol was 0.269.
Yes. I had paperwork to prove that. I had a medical augmentation that when I do drink, it's a lot higher. If I drink a couple of single shots, it'll blow up to 3 times the amount that I drink. I can use mouthwash and it'll still show up the visible number of alcohol.
So what does that mean for you moving forward with alcohol?
It means that since I have seen specialists and got correct medical treatment, that's not an issue.
You think you should be consuming alcohol?
No, not at all.
Okay. Mr. Rakowski, anything to be asked for people? This is the victim's case also.
The victim is here. I don't see her. I would say to the court that the pre-sentence investigation is accurate, and we ask you to adopt the recommendations as made.
High Court comes before this court with 2 prior misdemeanors. 12-year-old daughter was witnessing this. And court finds that there are some issues relative to alcohol. Not admitting to an issue, maybe medical, however, 0.269 regardless of any medical condition. It's not a blood alcohol level to be having, especially when you're making contact with police. However, considering the defendant's history, considering the plea offer that's been recommended in this case, the court is going to adopt it. So relative to count 1, the R&O charge, defendant was placed on, excuse me, delayed sentence for a period of 12 months, and we'll get a date in just a bit. Those conditions include standard conditions not to violate any criminal law of any government, not to leave the state of Michigan without prior approval of the court, notifying the agent at least monthly or such times as the places the agent may require, no use or possession of alcohol, period. Cannot enter bars or other places where they serve it. He's complied with requirements of alcohol and drug testing as directed by the field agent, follow all those rules. He must not use or possess any controlled substances unless duly prescribed by a licensed physician. Can't be around anyone that possesses those items, nor can he use or possess any drug paraphernalia or be around anyone that possesses those items. He's completed any substance abuse assessment, outpatient or residential substance abuse treatment when referred by the field agent. He has completed any mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider. To waive confidentiality, allow any treatment program he's required to intend to disclose that information to the agent. Comply with the DOC's electronic monitoring program. No assaultive, abusive, threatening, or intimidating behavior. No verbal, written, electronic, or physical contact with anyone housed within an MDOC facility, nor the same type of interaction with anyone engaged in behavior that constitutes a violation of any criminal law of any government. He cannot use any object as a weapon, own, use, or have under control, area control, a weapon of any type, cannot possess an imitation weapon, can't be around anyone that possesses any of those items. Excuse me. He's contacted supervising field agent no later than the first business day following his placement on probation. Comply with all written and verbal orders of the department. Allow the agent to his residence at any time for probation supervision, where he's subject to a search of his person and property, including but not limited to his home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause he has items that violate the terms of his probation. Any arrest, police contact, loss of employment, or change of residence must be reported to the field agent within 24 hours. He's to notify the field agent of service as any personal protection order within 24 hours of service. A genuine effort to find and maintain legitimate employment at a minimum of 30 hours per week unless engaged in alternative programs approved by the department. And just to be clear, all of those probationary terms also apply to count 2. As to count 1, though, specifically, crime victims assessment of $130, probation supervision fee $30 per month regular, $60 electronic, court cost of $200 payable at the rate of $20 a month, a fine of $150 payable at the rate of $15 a month, no attorney fees, DNA testing $60, state cost, and this will apply to applies just to count 1. $68 in state costs, count 1, $50 in count 2. If referred, he is to successfully complete any PA 511 programming based upon eligibility. As to count 2, I've already given the terms of probation. I've already mentioned $50 state cost, and again referred successfully complete PA 511 programming based upon eligibility.
And Your Honor, the standard conditions for both files, correct? Standard conditions of probation for both files.
What do you mean by standard?
Not leave the state, not violating criminal law.
Oh, I say that right from the start.
Thank you, Your Honor.
Yep. It's my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, court will expense. He's to initially receive questionnaire form requesting the assignment of counsel. both of which must be executed under oath, filed with the clerk of the court within 42 days.
Yes.
Yes.
Okay.
Probationary term on count 2 of 12 months.
And also the sentencing date will be August 27.
August 23, 27 will be the review date on count 1. Any questions? Good. You'd like to, sir. See you in a year.
Now in hour 2 of TCF Live on a glorious Monday. I hope you're all enjoying your day so far. Let's go to Texas, check in with Judge West in the Monday Morning Fashion Show.
All right, you're Desiree D. Yes, ma'am. So, Ms. Doucette, you were here before in cause number 26, DCCR 0757, correct? The deadly conduct case?
Yes, ma'am, that's correct.
And then you were given some time to hire a lawyer, and now it looks like you were arrested on two harassment of public servant and a DWI after that while you were on bond. Is that correct?
Yes, ma'am, that's correct.
Did you get a lawyer hired?
I looked into the 3 lawyers like my court order said, and I actually went with one, but I didn't pay him yet, and I was supposed to have an appointment with him. But due to my transportation, I didn't make it. I had to call him to reset another appointment so that I could go ahead and get him obtained. I spoke with Marvin Lewis. I've also spoke with Brittany Holmes twice since I've been arrested the first time. And I spoke with her again since my initial appearance in court. I spoke with another Miss Reagan Minaldi. And those were the 3 that I talked to. But I talked to Marvin Lewis, and he had payment plans that seemed to be sufficient with my budget and with all I have going on.
I'm just taking a look at something. So you paid a $20,000 bond in that deadly conduct case. And then in these new cases, the magistrate was, for some reason, kind enough to set you $10,000 bonds on each of those, which in my opinion is too low because you were out on a felony bond and are now alleged to have committed 2 new felonies. You have 2 weeks to get a lawyer hired. I'm going to let a lawyer know that was court appointed on your case that we may be having an issue with your bond. Mr. Nichols, this is your case. If you'll take a look at that, just one that gives me some concern because she was on bond already. So you need to get Mr. Lewis or someone hired before that next court date. If you don't, then you need to bring me more names of who you've talked to, and then we'll discuss what's going to go on in your case. Yes. All right. Step in front of the clerk. Do you have, let me come back. So on that bond on the DWI, I know it's a misdemeanor, but did they make you have an auto ignition interlock device or any type of
No, ma'am, because it was in my vehicle, and I know that I'm supposed to wait on my lawyer to kind of like go over everything with him so he can kind of tell you about what happened. But I wasn't the one operating the vehicle. I ended up.
No, you switched seats.
Yes. Mm-hmm. Yes,
I've already read the probable
ma'am.
cause.
Yes.
So, but you were intoxicated enough to think that that was a good idea.
Yes, and I was trying to just use my driver's license because my friend, I don't think had hers.
Let's don't talk about more of that without you having an attorney here. If I test you this morning, will you have anything in your system?
Possibly.
Have a seat in the jury box. We're going to double check that. Oh, thank you. I couldn't find it on mine. That's what I was looking for. Thank you, ma'am. David LeBlanc. Good morning. You're David LeBlanc.
My lawyer's on vacation,
Who's your lawyer?
Ralph Kindler, and
Did you actually go hire him and pay him money?
I've only partially paid him, so I need some more time to get with him. So, and I was kind of confused why he wasn't on this case the last time I came here.
Well, he's still not on the case because if you haven't paid him in full, he's probably not going to get on the case.
Right.
But you need to call his office and talk to his assistant about that, which is why I reset your case for 1 week for you to get that taken care of.
That's what I'm gonna do when he gets back in.
No, that's what you do now. That's what you should have
Okay,
done last week. He
secretary.
still has some, yeah, I mean, he has an assistant.
Yeah, sorry. I was just talking to him. I wasn't really talking to his secretary. And he didn't tell me he was gonna be on vacation this month.
So how do you know he's on vacation now?
Because I was in misdemeanor court last week. And they told him.
Okay.
Daisy.
So you didn't call his office.
I'm gonna do that today.
When's he back? That's fine, go ahead. Is there not a letter on file? Wouldn't be in the case. It's wherever the attorney vacation,
And I don't. I'm just down, like where like my words to get showed what the attorneys are favorable against me. It's not on there, but I know it's just that it hasn't done. But I don't know.
how to get to that letter.
Yes.
Christy, you don't know how to get to that, do you? All right, I'm gonna reset your case for 2 weeks. You need to get Mr. Kimler hired before that, talk to his assistant, find out what you need to pay, get that taken care of before that next court date.
Yes, ma'am.
Step in front of the clerk.
Ashley, thank you for the $5 super chat. Prayers and thoughts for Barbara and her family during this time. I totally agree. Just to kind of loop everybody in, Barbara's with her mother this morning, and we'll leave it at that. So, prayers for Barbara. Also, real quick, while we're waiting for the next contestant, sidebar panelists, go to Backstage at some point today, please. If you're not currently signed up for Backstage yet and you're a sidebar panelist, fix that, please, at your earliest convenience. I made a significant upgrade over the weekend to help us in crafting and picking show topics. So participation appreciated. Thank you.
And later. Jerry Dickert. Good morning, you're Jerry Dickert.
Hi.
And did you get someone hired, Mr. Dickert?
I did not get them hired. I did speak with them about their payments. They're wanting $2,000 as a retainer, and then they'll discuss payments on the full case. It's the Huff Law Firm in Houston.
Huff?
Yes, ma'am.
Okay. Are you planning on getting them hired?
I am. I finally figured out my transportation situation last week, so I'm making to get a job now. And
Okay.
actually I have a job interview
You do? Okay. So I say you've done everything I asked. If you want to fill out the paperwork for a court-appointed lawyer, I'll allow you to do that. Obviously, if you qualify and your circumstances change, that may change later. But if you want to fill out that paperwork this morning, then I will allow you to do so. All right, step in front of the clerk and she'll give you those instructions. Kira Douglas. Good morning, ma'am. You're Kira Douglas.
Yes, ma'am.
And Ms. Douglas, this is your initial appearance in 3 cases. You've got cause number 25 DCCR 1000. You're charged with the 2nd-degree felony offense of assault on a peace officer from June 27th of 2025. And then you've got 25 DCCR 1853 and 1854. And in each of those cases, you're charged with the state jail felony offense of injury to a child, and that's from June 27th of 2025. Have you, since you've made bond in all 3 of these cases, had an opportunity to try to hire a lawyer? So
When I went to jail, I lost my job, so I was trying to find a job so I can pay one.
okay, so what I'm going to do is reset your case about 30 days to give you some time to do a couple of things. 1, to get a job, and 2, to start talking to attorneys so that when you get some money saved up, you'll know who you want to hire. So if you get someone hired, or if you just get a job and you haven't gotten someone hired, bring me some type of proof of that. If you've got a job, bring me something, documentation that shows that. If you don't have a job, then I want you to bring me a list or documentation of everything that you have applied to, and it needs to be more than 1 or 2 a week. And then we'll discuss your options. You also, again, need to start talking to attorneys so you have an idea of what they charge. And if you do get someone hired, you're going to get a reset notice today. Bring that to the lawyer. If you do hire them, they'll tell you what to do. Otherwise, I want you to at least talk to 30. Okay, so you have an idea of what you can do when you do start making some money. If you don't do those things, then when you come back, you run the risk of me raising your bond for not following those court orders, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice. Dimitria Freeman. Good morning. You're Dimitria Freeman.
Yes, ma'am.
And you good? Ms. Freeman, this is your initial appearance in cause number 26 DCCR 1317. And in that case, you're charged with the 2nd-degree felony offense of assault on a peace officer from June 14th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, just due to the fact that I didn't even know I was getting bonded out. But I got a job, so I can work on it.
Where are you working?
Look, sis.
I'm sorry.
Look, sis.
Okay. If I test you this morning, you gonna have anything in your system?
My shit. Last time I smoked was last week on the 20th.
Have a seat in the jury box. Let's test you. Bernice McIntosh. Good morning. Are you Bernice McIntosh? And Mr. McIntosh, did you get someone hired?
I talked to Langston Adams. He told me I can I told him I have 6 kids. I had to get their school, paying for a bunch of school clothes. He told me I can pay him this month. Also, I got a misdemeanor similar to this case. I got a court-appointed lawyer. Forgot her name. I talked to her last month when I was here. I actually think she'd be my court-appointed lawyer in this situation since
It doesn't work like that. It's totally different. Yeah, the 2 courts. And so.
But I did talk to Mr. Langston Adams, and we talked about a price, and is a reasonable price, and I told him I could get him that payment.
Okay, so you think if I reset your case one more time, you'll be able to get Mr. Adams hired? So I'll give you just another normal reset. It's about 30 days. If you get Mr. Adams hired, just bring that reset notice. If for some reason it's not going to work out with Mr. Adams, then I need you to call at least 3 others, see if you can get someone else hired. And if you can't, bring me the names of those that you've talked to, and then we'll discuss your options.
Yes.
Okay, step in front of the clerk. She'll give you a reset notice.
Okay.
Derek Moody. Good morning. Are you Derek Moody?
Yes.
And Mr. Moody, this is your initial appearance and cause number 26 DCCR 0930. You're charged with the state jail felony offense of theft of property from June 3rd of 2023. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. The thing was that I was in New Jersey. I just came back like last week.
Okay.
So I still need to go talk to him and
Okay.
pay
Who are you planning on hiring?
Provost law firm.
Okay.
And his name is Matthew, but
Okay.
I still have a little bit of time.
Sure. So what I'll do, Mr. Moody, is reset your case. The normal reset is about 30 days. If you get someone hired before the next court date, just bring the reset that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yeah.
All right, step in front of the clerk. She'll give you a reset notice.
All right, other than the Rastafarian shirt, a relatively calm Monday morning fashion show. I will keep an eye, though. But let's go to Fulton County, Georgia, because we don't get to see her that often. Judge Manning.
Okay. All right, it's 25 PI 010352.
Released 12, 24, 25, no new arrests.
All right, go ahead.
No known violations within the last 60 days.
All right, go ahead, counsel.
I'm asking that the ankle bracelet be removed.
It says this date.
Obviously, we object to any removal at this point, given these allegations in connection with what we last time we recorded the offense that we have before us. We believe that it is.
So he said it onsets when? Anybody know?
12, 24, 25, when he was released.
All right, so who's December 2025?
And he was supposed to get it removed, but we came here and there was an allegation that 1, he texted the alleged victim, and 2, that he requested, they both work for the United States Postal Service, that he requested her shift. I have his records from T-Mobile showing that on that day, he did not text her, and a letter from his employer, the United States Postal Service, saying something totally different, showing that they were the ones that dictated his shift, and that the shift does not overlap with her shift. There's a 4-hour window in between it. So, and one more fact, in the underlying case, she was eventually charged in the same case with lying to the police about something very big in this case. The fact that, she told the police that he came to her house and it was shown that she came to his. So they filed the false report on her. And this is who we're dealing with, someone willing to falsify text messages and someone who's lying about his employment. So I'd ask, it's been months.
Well, first of all, I understand, counsel, when we dealt with this issue before, there's nothing in the order that's saying that this is a mandatory. And I know we're going to get into this problem connection with this language being on bond orders. That's a secondary issue. The mere fact that these allegations exist in connection with these charges prevents the state from consenting to the removal of this
ankle monitor.
If you want to recall that, and certainly it is within the wide discretion of this honorable court to do so. We address these issues with counsel they are troubling in connection with the allegations.
The alleged victim is now,
Here last week, and we did have counsel speak with her. I can't speak to anything in terms of their discussions with our colleague, Mr. Pete, in this matter. So to your discretion, we just simply will not be consenting.
I'm sorry, do you need the defense attorney's name?
Yehuda Brook,
Can you spell it for the court reporter?
Yehuda Bruck. Sorry.
No, that's okay. All right, I'll go ahead and remove it because it's coming up on, what's this, August, September? Yeah, it's coming up on almost a year, so I'll go ahead and remove it, okay? But it doesn't mean if you violate, you won't get put back on one. All right, have a good one.
Thank you, Jim.
Was it number? Is it 18, Courtroom? Okay. That is number 18, Madam Court Reporter, 25 SC 006766, Juwan Horton. Counsel, you want to put your name on the record for the court reporter?
Nautica Rollins on behalf of Mr. Horton.
All right.
Sorry, my calendar is out of order.
Oh, I was taking private attorneys for.
Horton, release 3/6/26, no new arrests.
There's no non-violations within since the last compliance hearing.
All right.
I apologize, Your Honor.
Yeah, no new arrests, no new violations. No new violations since the last time.
Your Honor, we'll leave that in the discretion of the court at this time, Your Honor. I believe this is an offense that has a victim in connection with person, if you want to call it that. It would be the state, given the charges, Your Honor. So we leave it in your discretion.
Judge, we're requesting that the ankle monitor be removed at this time. Mr. Horton has shown for the past 6 months that he is able to live without it. We have upcoming court dates, I think in January, and so we're fine with proceeding.
Okay, all right, so we'll go ahead and remove it. If you, where do you want them sitting? Yeah, if you just sit right over there, they'll take it off in a few minutes, okay?
Thank you. Thank you, Judge. That's all I have.
Thank you, yes, ma'am. All right, now we got that way. Was it number 21, Michael Jones? Number 21, Bostic Michael Jones. 26 PI 001166. All right.
No new arrests, 3/7/26.
We have no new violations.
All right. Mr. Jenkins?
Yeah, given the offenses, Your Honor, the state certainly does not consent to remove until these matters are adjudicated appropriately, Your Honor, in this case.
All right, go ahead, counsel.
Yes, Your Honor, defense just asked that the ankle monitor be removed. This is a traffic case. My client does not know the victim, has no reason to contact the victim. In fact, I don't think the state can explain what conditions are set on the ankle monitor other than tracking it. He has no curfew. He has no restriction. Essentially, he's just wearing it at this point.
People pay good money on Amazon to buy these. It's a status symbol. Do you know that? I don't know what that means, but it's a status symbol. Let's see here.
They can have his for free.
No kind of like no driving, no nothing?
There's no restrictions on it at all, Your Honor. He's just wearing it. In fact, when they gave it to him, I argued we couldn't understand why they gave it to him, but the state asked for it and the judge granted it.
It was supposed to come off September 6th, so we'll go ahead and remove it.
Thank you, Your Honor.
All right, let's see. All right, Mr. Rena Camarillo, number 25, Alexis Houston, 26 PI 001906. Number 25.
Thank you.
Mr. Jenkins, how are you doing today?
Good to see you.
You too, sir.
No new arrest 4/1/26.
All right,
Minimum violations within the last 60 days.
all right. I said the state.
Your Honor, we have been in contact with our victims. We do not consent to the removal. We believe it is appropriate as is and maintain the appropriate matters. We just heard from the investigators in this matter. Certainly, these are merely allegations as they stand. However, we do not consent to its removal.
Bostic, was there a criminal history before this?
I can look. What was the name you said? On prior arrest.
All right, go ahead.
Good morning, Your Honor.
On prior arrest in Georgia, she had one cycle, it's a misdemeanor of
Traffic.
exchange and drug paraphernalia, so misdemeanor drug hits out of Tennessee.
Okay.
25.
All right, counsel, go ahead.
Good morning, Your Honor. Miss Houston has practically no criminal history other than maybe a traffic offense and a misdemeanor drug. Although this allegation against her is a serious one, they are just allegations, as Mr. Jenkins did state. But more importantly, Judge, because of this calendar and what we're here for, Miss Houston has she does gig-based and give new coordinates and give new places where she's going to be. It's extremely difficult for both herself and the company to maintain this this daily task. And so what we're asking Your Honor to do is to remove it. She has no violations. She's been in compliance. And so at this point, we're asking Your Honor to remove it.
All right. Mr. Jenkins, I'm sorry, Mr. Jenkins, anything else?
No, Your Honor, as other than what we have already stated in connection with our victims' positions and the state's position, Your Honor.
All right, so she has to call every time she gives them coordinates, or does she just say, hey, I'm going here today?
She calls and emails them and says, I'm going to be in this position. I'm going to be here. I'm going to go here, you know, from here to work, to school, different places where she's allowed to be. And it's daily because her work changes daily based on the needs of different clients and different people that she's working with.
Yeah, because her schedules, what else can she do to make it easier?
I mean, speaking on behalf of Basic and Chance, we've been able to monitor her, and I've put in all of her addresses that she is stating that she's doing with her work. So, I mean, it really hasn't been a problem on our end. But I mean, she does have to email us because her schedule's changed based on all the businesses that she has.
Right. However, school, you know, your school schedule, right?
So as far as school and everything that I'm doing, basically it's just like right now I need to go to Loganville, Monroe to go pick up my actual, I guess, register, get that to the actual school. It's just a lot of movement, and I am on, I guess they call reporting. So it's not like they're just watching the monitor. They want to like know the address. They want to know who owns the house that I'm in. We're cleaning. Enough.
Yeah, this exception, do you see the exception? Thank you, the exception.
24-hour curfew, house arrest, except for legal matters, medical, religion, work in school, no contact with.
Never put that. I tell you what, you're supposed to say, you know, our policies are going to stay on 6 months. So unless there's anything that they notify us about for October 1st, go in there and do that. But to me, you go in October 1st. To me, though, if you have a school schedule, like I go Monday, Wednesday, Friday, these days at wherever, then you should be able to just do that. And if you know the day before, do you know the day before we're going to be working?
No, ma'am. So sometimes it's the day of like just just this passing, I actually left and I forgot. So I left, did my work, and then I had to email them back so that they didn't violate me. There was one time I was cleaning my Airbnb. I had to go back because the guests wanted me to do the walkthrough with them. I got violated, but then I had to go back and explain. But it is very scary. I've had to leave work multiple times because Danielle and Jewel are very good with me, but sometimes they don't know me, the person I'm talking to. They're younger. They don't understand the severity of my case and what I'm up against. So it has caused a lot of like just disconnection between my actual work being on time. Also like when people see it on me, it's not the easiest thing to, explain. And I'm not in a line of business where these people are like, they can't look it up. They can look my background up. So it's not like it's hiding from them, but the monitor itself does give me a preemptive, how people look at me in my line of
Do
business.
you wear pants most of the time? Because that usually covers it up.
I try to, but it's very hot in Atlanta right now. But I do, I have been.
Oh, good out there right now.
But yeah, as far as like skinny leg jeans or anything like that, I have not been. I've only been wearing flare pants and trying to keep it covered as much as I can, and pulling it up my leg when I'm at work of jobs. Like I do gig work, like you said as well. So when I'm in a restaurant where no one knows me, I try my best to hide it, but also I don't only own flared pants. And again, these are all allegations. There is no.
Yeah, I got it. So, well, since they put, or like I said, we usually put it on for 6 months or whatever, but I'm trying to figure out a way through second chance, an easier way for you to let them know your schedule, or if you don't know it.
I think that from what I know, other people, they don't have to do the 24-hour monitoring. They right now are expecting that information based off the judge's saying of, I have to do that, the 24-hour constant update, but isn't there?
Well, most of the time, if I put it one, I'll give them those reasons they can, and then they're supposed to notify them. When they leave, I usually give like work, religion, school.
So the reason that she has to notify us, Your Honor, is because she doesn't have a set schedule because she has multiple business and gig work that she does. So unfortunately, we have to verify that that's trackable work. So unfortunately, she has to send us that documentation so that we understand where she's going is for work and it's not that she's just meeting up with someone.
She has to email you ahead of time.
Correct, because we have to know where she's going to make sure that it is actually work and trackable. And unless she's provided us with her Airbnb addresses, then as long as she's going there, we know that's for work and she's not making any stops. So I put in all of that. I put in where she said she has a cleaning business at a barber shop. So all of those addresses, as long as she's able to provide that to us, we have placed that in her profile. But unfortunately, she does have multiple businesses. So therefore, we have to have the contract to make sure it is trackable, that she's able to go do that for work.
So if she leaves here today and goes to the barber shop, she won't have to tell you where she's going because you'll know?
Correct.
You go to most of the same places all the time?
No, so that's what we're trying to explain. Like, as far as my work, again, like just a few days ago, I woke up with a queue full of cleaning. So I had 4 cleanings I had to go do.
But they have the addresses.
So those addresses didn't come in until that morning. I woke up with that morning of the queues of the addresses on my TaskRabbit is one of the platforms that I use. And Upwork, Upshift, gig work. And then my clients come from a bunch of those, retain it. And that's when they are able to see those addresses. And I let them know, hey, this client has gone ahead and said they want to keep me. And that happens. Most of my clients keep me. So we add the addresses. There's a bunch of addresses on my list that I continuously go to on a regular basis. But from what I'm aware, there are other different types of monitoring. I don't mind monitor. It is embarrassing, but I don't mind it. But just the constant back and forth. And then the people that are not Jewel or Danielle, the in-betweens that are not aware when my account is not updated, when I have to go back and make sure that the addresses were put, and then I violated for something I've already spoke to someone about, but it didn't make it down the chain in time. So now I can't leave for work on time, and now I've lost another customer or another client. Also, my medical history, I'm not allowed to stop and eat. I can't go to the grocery store. I can't do anything that I need to do on a daily basis of me working 12 8-hour shifts a day. I'm not allowed to stop for anything in between other than a gas station, and I have to figure out food there.
Go ahead, Mr. Jenkins.
Well, as we said, it was merely allegation in this case, but one of the allegations we're making is that those who were working for her, she's abusing in connection with this incident. So I believe it's proper for its removal, the stage.
All right, so we'll let you get it off October the 1st, but I know we can add like grocery store, what do we call it usually, like
Basic life
basic
necessities.
personal necessities, right? Like grocery store, get gas. What do we put last time? Basic life.
Life necessities.
Yeah, basic life necessities. So,
That's what I heard
That'd
it
be
called,
great.
it was called.
yeah, so we'll put that.
Yeah, the addresses, but I can then eat food and go to the grocery store.
Yeah.
Do we want to come back in September?
September 20, if we get you back here September 21st, if you're doing fine, then probably take it off a little early.
Gotcha.
So it'll be September 21st.
And Your Honor, I just want to clear, so basic life necessities, we usually are like for grocery stores, it's not fast food restaurants, so I just want to clarify that with you so that I can make sure I update her profile accordingly.
Is that good?
So the appointment for that was for when I'm out doing these
Oh.
cleanings and I'm doing shifts back to back so that because right now my only option is to go back home and eat or don't eat until the end of the day. And we have been working towards the necessities, so.
So you're going like in between one job to another?
Yes, it's like address to address, back to back. And when I do know the day of, like, for example, I don't have my phone, but for example, just the last message I sent was over 4 paragraphs long every day.
Right, so you can stop at a fast food like in between your,
I appreciate it.
in between your jobs, okay?
Thank you,
And
Judge.
we'll see you back September 21st.
Thank you.
Uh-huh.
Thank you, Judge. Great seeing you.
Yes, sir. Good to see you. All right, I think that's all.
Good morning once again, everybody. TCF Live on a Monday. Barbara stops by. Ashley and Austin, thanks so much for helping out today. Thank you all at the TCF family for your support at this difficult time. So Barbara, thank you for that $10. And as Ashley said, we've got you. Go be with your mom. Thanks for stopping by, but be sure you spend your time with her, and we'll be here. We're not going anywhere, and we're praying for you. All right, let's go to Texas. Judge Boyd.
Case, or was it waived?
Pardon?
Was the PSI done on this case or was it waived?
No, it was done. We appeared back on the 30th of July in this case. I had filed, you had an answer or a question about home visits in Medina County. I filed a response. If you didn't get that, I've got an
No, I didn't receive that.
If you'd like, I can give you my tablet and let you read it.
Oh, any objections to my reading that?
No, Your Honor.
Thank you.
I showed it to the state. First is obviously my email to them. And attached to that is their response.
Thank you.
Did you scroll up?
Oh, didn't.
Yeah, scroll all the way up.
I think there's an email at the end.
Yeah, there's an attachment at the end of that from Medina County.
Okay. Oh, I take your word for it when you say they can. Okay, awesome.
And I said that was filed last week.
Okay. All right. And you say a PSI was done in this
It was.
case? Does anyone have a copy of the PSI?
I didn't get it this morning.
I have it as late on my paper. Yeah, that's what I thought too. Because I don't have a copy of a PSI, counsel. And I thought it was waived as well.
Well, maybe it was. It may have been, Judge.
Okay, I just wanted to make sure.
A month ago.
Yeah, because I think I only had one question.
Oh, I agree. Yes.
All right, the court is calling 2026 CR 003517, State versus Jesse James Noel Hester. Can I have parties announced?
Daniel Escobar for the state of Texas.
Butter and I for the defendant.
And are you Mr. Hester?
Yes, ma'am.
All right, we were here in July. You entered a plea to a cap of 8 years. The state is opposed to your application. And this is run concurrent with 2026 CC 008057. One of the questions the court had was whether or not Medina County would do field visits because the court wanted that information. And counsel, you obtained the information?
I did, Your Honor. He lives in Natalia County, which is in Medina County. I've contacted the probation department down there, they have indicated and responded, and I have filed a motion to this effect, that they will do home visits. Their comment was they can do it in conjunction with the home visits they do with sex offenders.
All right. And state, the court is understanding why you would be opposed to his application. So other than the facts.
No, Your Honor.
Okay.
Nothing else.
All right. Thank you. I have some questions for you. You want to raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand, state your name for the record.
Jesse Hester.
All right. What's up with this tattoo on your face?
I had gotten it whenever I was bad on drugs, whenever I was younger. It didn't really mean anything. I didn't know what it meant at the time.
All right. So you're telling the court you have no gang affiliation?
Yes, ma'am.
All right. I'm telling you right now, you're going to be evaluated for gang affiliation. If it turns out you have a gang affiliation, we don't have issues.
Yes, ma'am.
Because I expect honesty. Do you understand?
Yes, ma'am.
I'm leaning towards granting your application for probation. There needs to be some type of punishment, counsel, based upon what I read in the steps. So if you want to speak to me about deferred adjudication, I know the state would have objections to him getting the deferred adjudication, but based upon the facts in this, I don't think he should obtain deferred adjudication. I think he should have a conviction on his record. So what are your thoughts, counsel?
Well, first of all, he's relatively young. He has come out of the drug stuff that he was in before, as he just told the court. He's in the process of getting his license. I think he's done pretty well getting his life straight at this point. If the court thinks he needs to deal with staying, then perhaps some days in jail as a condition might satisfy the requirement.
All right.
If you put him on deferred, obviously you've got the hand rip over him.
If you're drug tested today, what will the results be?
Negative.
And you will get a drug test today.
Yes, ma'am. Negative.
All right. So what have you been doing with your life?
Recently I've been on house arrest, but I do have a job coming up for contracting. I don't know. You mean like before I would?
No, now, currently.
Now I'm on house arrest, but I do have a job and I have a letter of proof that I do have a job.
All right. And what will you be doing?
Contracting.
Okay. All right. I'm going to have him do a drug test today. If the drug test is negative, place him deferred adjudication. If it's positive, we're going to have some issues.
Yes, ma'am.
Because you will be dishonest with me. Okay.
Yes.
All right. Probation. Can you send him for a drug test? All right. So they're going to send you for a drug test. It doesn't cost anything. Do you have your identification with you?
I do not.
Oh, they'll take a photo and send it.
Okay. Yes, ma'am.
All right. So just.
And she's muted. Go figure. Alrighty, friends, let's go to Michigan. Let's check in with Judge Elmore.
All right, folks, good morning. We are on the record today now for the 28th Circuit Court here in Wexford County. And we begin today and this week by taking up People of the State of Michigan versus Alonzo Ladon McLean. File number is 26-14237-FH. Appearances from counsel, please.
Joanna Carey for the people.
Robert Hartzell for Mr. McLean, who joins us by Zoom from, I believe, Carson City Prison.
Thank you. Mr. McLean, are you able to see and hear us this morning, sir?
Yes, sir.
Thank you very much. Also before the court this morning is Miss Lindsay Simmons. She's the agent from the Department of Corrections, which prepared the pre-sentence investigation report. We are here today for sentencing in this case involving a conviction for possession of the controlled substance methamphetamine. The court had received this report. It was originally set for sentencing back on July 20th. So obviously we need to change that date.
Yes, sir.
And we have an update at all for pretrial credit.
Your Honor, he's serving a sentence out of Osceola.
Oh, that's right, because you wouldn't get credit for it anyway, so it's correct. I'm sorry, thank you.
Thank you.
But still, we should probably include that on CFJ 145, page 2. That would include at least a date until the day's date, and then you'll still leave that note that he's currently serving that sentence. Does that make sense?
Correct, Your Honor.
All right, great. Thank you very much. Let's take a look here to see if we had any other corrections. I did. All right. It looks like I caught any other need for corrections. I know this was largely an update from the PSI of another case from another county. How about you, Ms. Carey?
No, none, thank you.
And how about you, Mr. Hartel?
Just a few very small ones, Your Honor.
Sure, of course.
CFG 145, page 1, it has the attorney listed as Mr. Harrison.
Oh, yeah, thank you. We'll go ahead and change that. Thank you.
It also has my client's ages 24. He recently had his 25th birthday, just for the course of the week.
Oh, all right, thank you very much.
And then on CFJ 284, A, page 2, on the second to last paragraph in description of narrative, they spell his name Alonda instead of Alondo.
Yep.
Not a huge correction, but he did point that out to me when I talked to him earlier.
It's all right.
No further corrections.
Thank you very much. Ms. Simmons, did you get that?
Yes, Your Honor. Thank you.
All right, great. Thank you very much. All right, let's go ahead and begin with allocution. I'll start with the people today. Ms. Carey?
Thank you. I'd ask the court to follow the recommendation.
All right, simple enough. How about you, Mr. Hartel?
I would also ask the court to adopt the recommendation, Your Honor. As was noted, even though he's not getting credit, he has been in there due to no fault of his own, longer than we originally expected him to be before we had this conversation. He has informed me, just so the court is aware, that he was resentenced on his Osceola case. They double checked his credit, and I believe he informs me that his earliest out date is September 24th of 2027, if I recall correctly. So if we could do the 11 months recommended, that would keep his out date the same. Thank you.
Thank you. All right, Mr. McLean, you have the right to make a statement before this court issues a sentence. Is there anything you wish to say at this time, sir?
I just ask that the court follow the recommendations.
All right, thank you very much. One moment here. All right. The defendant is a young man of age of 25. He is currently serving a prison sentence out of Osceola County. And in Osceola County, the offenses apparently occurred on September 2025. Included multiple counts of delivery of the substance methamphetamine. At least that's, I'm sorry, the offense date was August 28th of 2024. He was arrested then on September 26th, 2025. Then it resulted in a plea of January 9th of 2026. While it did not result in a conviction, only make the note that it was dismissed as part of a deal in the other case, but he had another prior allegation, and it's strictly an allegation, and it's not weighing on the court because I don't have any finding of guilt. But on August 1st of 2024, allegedly had committed similar activity in Osceola County. And the reason why I'm making note of this is just so I can state out loud for the record, the court does not consider that for the sentencing today. All right, so now we take a look here, and this is the defendant has, as he's a young man, only a couple cases in his prior criminal history. However, in this case, he is dealing methamphetamine. In this case, while he's found guilty of a possession of methamphetamine, it is clear from the description of the offense for which the court accepts and makes a finding on a preponderance of the evidence that not only on August 11th for the offense, which is the date which he's charged here for, he had come to the county to deliver, went out to the Burger King. And hold on, did I get this one right? Oh, then he went to the Murphy's gas station here in Wexford County after apparently going down to Reed City. And made a transaction of $500 for a controlled substance of methamphetamine. Previously, there had been some arrangements apparently on July 25th of 2024, and then the offense here occurred on August 11th of 2024. What we have here, so is a young entrepreneur, although I highly doubt that it's all him. I strongly suspect that it's coming from somebody else, but he is making a choice to be a drug dealer or a drug mule or whatever you wish to call it. I find that the guidelines are inadequate to not discuss the true nature of the offense for which he was here in this county committing and spreading methamphetamine, which delivery of methamphetamine is one of the highest problems and most significant problems we have in our county. And sure enough, the defendant is from Muskegon County. Now, I mention that because part of the objectives of sentencing is deterrence. And I want Mr. McLean to be able to share the message with his group of people down in Muskegon. If you come up here to Wexford County, you start peddling methamphetamine in this county, which takes up about a third of my caseload. I want every one of these people down in Muskegon who are behind you, Mr. McLean, and know that it is not acceptable up here in Wexford County. It shouldn't be acceptable anywhere. But what you are doing is you are committing one of the most serious criminal offenses we have in Wexford. While there are other cases that include violence and domestic violence and so forth, and those are extremely important, methamphetamine is right there at the top. So, I'm going to give you a prison term today. And while it's an intermediate sanction cell, I find that there are reasonable grounds because this is a repetitive problem coming from Muskegon. And you know who these people are, and I hope they get to know this court and know this county, and that if the message is going to be sent, deterrence to you, deterrence to them, deterrence to all the people who come up from Muskegon to deliver this substance in our county. So the sentences of the court, by the way, again, reasonable grounds, and if I'm proportional. I don't think you're going to find a case where somebody's come up from Muskegon or you find anybody at all, even from the local area that's dealing. And if anybody pleads this case down, a charge for delivery, and I think, and there's clearly evidence that they're here to deliver, and if they pleaded to a possession, the likelihood of them getting the prison term is extremely high. The proportionality is this. It is one of our #1 felony offenses. It kills people, it ruins communities, it ruins families. Make sure you get that message out to those who helped you on this case in the background. $68 state minimum fee, $130 crime victims' right fund fee. The court sentences the defendant to a prison term of 15 to 120 months. Hold on, I'm gonna go 13, take that back, 13 to 120 months. And because of serving a current sentence, he does not get any credit. All right, that is the sentence of the court. And I find it to be reasonably proportionate to all those factors that I've already discussed. This is just a continuing pattern of drugs flowing up from Muskegon into our northern counties. And I wish we could get the message out even stronger. That is the sentence of the court. You will receive there at the prison a notice of your appellate rights. You have the right to appeal the conviction and sentence in your case. This is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal and not a claim of appeal by right. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, You may complete the bottom half of that document that you're going to receive and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, this will run concurrent with what the sentence that he's currently serving. There are no reasons for, no automatic reasons for consecutive sentencing. The court, within discretion of the court, I think could, but the court chooses not to do so. Have I missed anything, Ms.
Thank you, Your Honor.
Ms. Carey?
No, thank you.
And Mr. Hartel? Mr. McLean, I've had several of these cases, and I really wish you all would stop it. Thank you very much. Do you have any questions today, sir?
Thank you. No thanks.
All right, thank you very much. We are adjourned.
So just to give a little bit of context, because Judge Elmore kept referencing Muskegon, I actually grew up in Muskegon. I was born and raised in that area. And that is a community that was very industrial once upon a time. It was built on the logging industry. There was a big paper mill there. They would float the logs down the Muskegon River as they were harvested, and then they would process them in Muskegon. It's known as the lumber town. A lot of manufacturing there to support the auto industry. Brunswick had a base there, some military stuff, all sorts of things. And then all of the manufacturing and everything started to go away. And once upon a time, Muskegon tried to shift to more of a tourism kind of economy, because they have very good beaches there along the Lake Michigan shoreline. However, the population did not support that. A lot of the improvements were immediately destroyed or defaced or things like that, so it was never able to take off. And it is kind of a community that is not what it used to be. So the fact that he's talking about all of these drugs rising up into Wexford from Muskegon, unfortunately does not surprise me. It is sad, but it is what it is, I suppose. Anywho, let's go back to Texas. Judge Boyd.
Court is calling 2025 CR 005084, State versus Matthew Luis Martinez. Can I have parties announced?
Well, that's even for the state of Texas.
Ben Stevenson for the defendant.
All right, and are you Mr. Martinez?
Yes, ma'am.
All right, this is set for a contested hearing. Is it no longer contested?
It's no longer contested, Your Honor.
We agree, Your Honor.
All right, so this is what I want to let you know. It appears that maybe your attorney has come up with some agreement with the state. I don't have to follow any of those agreements because this probation that you're on is a contract with the court. It's not a contract with your attorney or the prosecutor. Do you understand?
Yes, sir.
All right. Did you review the motion to revoke community supervision and the first amended motion to revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Matthew Luis Martinez who was placed on community supervision in 2025 CR 005084 for the offense of a burglary of a habitation on September 18, 2025 for a period of 5 years? Is that you?
Yes.
All right, state.
Your Honor, the state will be proceeding on the first listed violation of condition number 4 in Bexar County, Texas. The defendant, Matthew Luis Martinez, did then and there fail to report to the supervision officer as directed for the months of February and March 2026 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
State will waive all remaining violations.
Any objection to the waivers?
No objection to the waivers, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you to 3 years in prison?
Yes, Your Honor.
And to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, before we get to the proposed agreement, I'd offer State's Exhibit 1. This is a copy of the report of the circumstances under which this violation took place. Out of that offense, there also was a prohibited weapons that the state will be dismissing in the form of a Molotov cocktail and an assault bodily injury that the state is going to dismiss for a missing witness. Essentially, this defendant.
Well, just 1 second. Any objection to the court reviewing State's Exhibit number 1?
With the stipulation that all alleged facts in that are not stipulated to, and that we are not proceeding on any new number ones arising from this.
All right. Well,
Yes,
the
Your Honor.
court will accept state's exhibit number 1 into evidence with the stipulations that are agreed upon.
Yes, Your Honor. The defendant has severe depression. He has some pretty serious mental illnesses, and he spirals when he gets into bad positions in his relationship. In this case, he was in a fight with his girlfriend. He spiraled. He went to his apartment, doused himself in gasoline, Molotovs, and threatened to burn himself alive. The police, luckily, fortunately, were able to talk him out of it. Everything ended peacefully. At this point, Your Honor, the state will leave it to the court's discretion. This is a straight probation of 3 years. I've spoken to Mr. Stevenson at length, trying to find some solution that would allow this defendant to be kept in a way that will keep society safe from him when he's in these sort of mental episodes, and we were unable to come to a conclusion of something that would be available to him. So I'll leave it in the court's discretion.
Your Honor, I'd like to respond to that.
Yes.
My client is on 5 years of probation for a 3-year sentence. He's already been convicted. He has had difficulty with depression. He has had difficulty in certain relationships. He has been in custody continuously for 3.5 months on this. We're looking forward to him having a chance to reboot. He's actually very intelligent. We've talked about some of the things that have caused him to have difficulties in the past and how he's going to proactively take the steps to avoid those in the future. I don't know if I heard an allusion to any form of commitment, but commitment other than for the remainder of his sentence on the burglary case is not warranted at this time. His mental state is good. He is extremely competent to stand trial. There is no serious question as to his sanity. He allowed himself to get into relationships where things were a little bit not good, and he's going to take active steps to avoid that in the future. At this point in time, we would ask that the state simply honor the agreement. We do have side agreements regarding the 2 other cases that we talked about, and the opposing counsel has informed the state of that. We simply ask the court at this point in time to revoke his probation and let him get the new start that he needs.
And sentence him to what?
What this court believes is appropriate. The state's concerned that this defendant presents a danger to himself if he is free, which is why we would not agree to a continuation.
We're not asking for a continuation. The legally possible sentences on this are anywhere from 2 years to 3 years because this was capped at 3 years when he was convicted. So we're asking the court, we're agreed as to 3 years. The court can do anywhere between 2 and 3, but we're agreed as to 3.
All right. Are you waiving your right to appeal?
Yes.
All right. So I've read the report and it appears that he was angry because he was having an argument with his girlfriend.
Yes, sir.
And this burglar of habitation, argument with a girlfriend. And were there any children at the location?
No.
Does she have any children?
Yes.
Here's the thing. You shouldn't be in a relationship with anybody until you work on yourself.
Yes, ma'am, I agree.
The burglar of habitation with someone, then now this other girlfriend. I don't know, is there any proof that he has anxiety or mental illness, or are we just saying this?
I've not seen anything. He did attempt to set himself on fire.
Well, sometimes people will attempt to set themselves on fires for attention, like, please don't leave me, I'm going to kill myself.
Could be, Your Honor. It was extreme behavior, the concern.
And some people, when you do that, you know what they will say? Okay, do you? You had better start working on yourself internally. If there are some mental health issues, which according to the notes I have, there was never any mention of mental health issues. It appears that you just can't be in relationships and you're not mature enough to handle relationships. All right, this is what the court will do. And you're waiving your right to appeal, is that correct?
Yes.
All right, the court is going to revoke. Court will sentence you to 3 years in prison. Give you credit for any time served. There's a $1,500 fine, time, and money will run concurrently. There's to be no contact with Vanessa Delgado. And who's the complainant? Well, the girlfriend in the other case?
In the original case, Your Honor?
Yes, it should be in the police report.
Oh, yes, Your Honor.
I think she's listed as 01.
Alex Reed, W. CHAIR. At least, yes.
There's to be no contact with Alicia, Marie.
Marie.
Shariva. Okay. There's to be no residing in households with minors. No unsupervised contact with minors. And I'll request the therapeutic community for mental health issues. With regards to the therapeutic community, I do not have the authority to force them to place you in the program. However, they are seeing the judgment that I'm requesting that for you because you say you have mental health issues. You'll need to request it as well, okay? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Thank you.
Alrighty, friends, hour 3 of TCF Live. Let's head east to Judge West, because Judge West is the best.
Good morning, sir. You're Justin Zurich.
Yes, sir.
And this is 26 DCCR 0317. Mr. Zurich is charged with driving while intoxicated with a child under 15. And what is the announcement?
Yes, Your Honor, we're still working on discovery for this one, and we need time for him to come to the office and review with us before we can make an announcement.
All right, so any issues?
No, sir, the offer has been extended.
This will be at the next court date. It'll be about 6 months since Mr. Galmore's hired, so it'll probably be time to get an announcement.
Yes,
Make
ma'am.
sure you stay in touch with your attorneys so you can go over everything with them, see what the offer is in your case, and then we'll see if we can get an announcement at the next court date. All right, you're free to go. Thank you, ma'am.
On that other case, I put a word in with Mr. Gilmore. He's reaching out, but I'm gonna go to another court.
Okay, thank you.
Thank you.
Ms. Holmes, you've got Trinity Bell.
Yes, sir.
Okay. Ms. Bell, your Trinity Bell. The state has just told me they're going to file a dismissal in your case this morning. I'll sign it as soon as it comes through. You're free to go. Right? Good luck to you. Cynthia Williams, Ms. Holmes.
Cynthia Williams. Yes, she's outside. Cynthia Williams.
Good morning. How are you? Good.
She's in the restroom.
Okay, I'll hold that for just a minute. Mr. Rojas, you have Keith Sean Davis.
Yeah.
Morning. Mr. Smith, you've got Keith Sean Davis. Good morning, sir. Are you Keith Sean Davis? And this is cause number 26 DCCR 0096. Mr. Davis is charged with aggravated robbery. And what is the announcement?
Judge, we have all the discovery. We do have an offer. I went over that with Mr. Davis last week. I need another reset. Let's get the information back to Mr. Smith.
Okay. All right, we'll do one more reset, and then we'll get an announcement at that next court date. Make sure you stay in touch with Mr. Rojas so you guys are prepared to make an announcement at the next court date. Thank you, Ms. Malfina. Tyler Douglas, Mr. Rojas.
You can share.
Good morning, you're Tyler Douglas.
Yes, ma'am.
And this is 26 DCCR 0905. Mr. Douglas is charged with burglary of the habitation. And what is the announcement?
Judge, I haven't had a chance to go over anything with Mr. Douglas. The number I have is no good. I know he was in the hospital last week. If we can get another announcement, Doctor, we'll be able to make an announcement, hopefully.
So before you leave today, Mr. Douglas, you need to visit with Mr. Rojas, make sure he has good contact information so y'all can talk before that next court date, but don't leave today and I'll reset your case, but don't leave until y'all visit. Okay. All right. Anything that I need to do? Okay. You can go. Thank you.
Thank you, Judge.
Mr. Parker, you got Terrence Jenkins. Morning.
Morning, Judge. Just they don't do blame on their face like they used to.
No.
God.
It's a whole thing.
It's horrible. Well,
Good morning. Are you Terrence Jenkins?
yes.
And this is 26 DCCR 0512. Mr. Jenkins is charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, we're asking for a reset. This was Mr. Coleman's case. Mr. Schmitz has looked over it and made me another announcement. He's actually called me when I was out of town and apparently had me hooked up. So if I could get a chance to get him in.
Sure.
I only need a couple weeks, I guess.
Okay. Any issues? All right. I'll do a normal reset. That should give you plenty of time, Mr. Jenkins. Make sure you call, make an appointment, go visit with Mr. Parker. You guys can go over everything and we'll get an announcement at the next court date. All right. We're free to go. Deborah Elliott.
Maybe taking that, Judge. You're going to sign that, sir?
Okay. I'll recall it as soon as it comes through.
Would you mind reading John Martin? In the Martin on the breakdown, would you mind?
Yes, I already signed it up
Yes.
here
Yes, I seen that a little bit ago.
on Burbanks. Got it. Thank you.
Yeah. I can write you, no, my reason.
That's all good.
Sorry.
Next week, the trial week. Let's see. Can I get a copy of the trial docket?
All right, looks like it might be a few minutes before they get another contestant. Let's go back up to Michigan, check back in with Judge Oakley.
Reading, Your Honor, so my client stands mute. And with regard to the pretrial, Your Honor, after speaking with Mr. Green, he is willing to avail himself to the 771.1 on this particular offense for the checkpoint violation.
What was agreed upon time frame?
3 months, Your Honor.
Thank you. All right, Mr. Green, did you discuss with counsel your rights and the options those rights give you?
I did.
And did you also discuss with him the possible penalty for today's charge?
I did.
And understanding all of that, are you pleading guilty to the charge today?
I am.
Are you doing so freely and voluntarily?
Yes.
Thank you. Counsel, I've got a June 29, 26 incident date at Metro Airport. Can you voir dire to get me the facts that support the plea?
Yes, Your Honor. Mr. Green, you were traveling for work on June 29th, 2026. Is that correct, sir?
Yes.
And your travelers took you to the Detroit Metropolitan Wayne County Airport, correct?
Leaving the airport.
Leaving the airport. Okay. Thank you very much, sir. And as you were leaving the airport, you attempted to take some items through the TSA checkpoint. Is that correct, sir?
Yes, sir.
What were those items, sir?
2 axes, three axes total, 2 for chopping, 1 for throwing.
Okay, okay, excellent, sir. And you knew those items were prohibited items, correct, sir?
No. No.
At the time,
You quickly found out, didn't you?
I did.
Okay. So, but you're aware now that those items were prohibited items, correct, Mr. Green?
Yes, of course.
Is that satisfactory, Your Honor?
It is. If you're satisfied, I am.
I'm satisfied, Your Honor.
All right. What should I know before I sentence?
Yes, Your Honor. I know I heard the factual basis as to what my client was taking through the TSA checkpoint. However, my client is a lumberjack. He travels the United States and performs in lumberjack shows from city to city. There was some confusion with the gate agent as far as checking his bag. He was then instructed to attempt to take the bag through TSA. It is his equipment that he utilizes for his shows.
Yeah.
I explained to him, naturally, the nature of the prohibited items, because at 37,000 feet, if someone spazzes out and decides to utilize those type of devices, you can have catastrophe mid-air. So the reasonableness of it is not necessarily there. But however, I understand his story that these objects are part of his display when he performs these shows at various cities. So I just want the court to be aware of that, Your Honor.
Thank you. Mr. Green, I'm assuming they confiscated the axes?
They did.
Yeah, and you don't buy these at Walmart. What'd that cost you?
Yeah, that was kind of my big thing. The two chopping axes between both of them, probably about $600, and then the throwing axes aren't too expensive. They're like 150.
Yeah, that's what I thought. Just out of curiosity, did you get a letter from TSA?
I got a couple things here, and I read through them all, but they sent me a couple duplicates, and
I'm just
all
curious
kinds
if
of
TSA
different
is
stuff.
trying to hit you with a civil fee.
It looks like possibly, yeah, but I could be wrong.
Okay.
It doesn't say anything like monetarily on this.
Okay, then it's
notice.
probably not that, because the ones that the firearm people that go through the checkpoint with a firearm and get charged, they get a TSA letter that's pretty clearly extortion.
Yeah.
Because it says if you don't pay them enough money, they'll put you on the no-fly list.
Yeah.
So that one's pretty blunt. So I think you'd see that pretty clearly.
Okay.
Anything you want to add to what counsel's told me before I set the terms of sentence?
Not really. I mean, the agents that dealt with the whole matter, they were pretty understanding, and I hope this is clear. The intention wasn't to bring the items onto the plane.
We wouldn't have this conversation if they thought it was.
Right. Okay. All right.
It would have been a whole different rodeo then.
Gotcha. All right.
Yeah.
Cool. Well, then no, we're all good.
All right. Can you avoid any new criminal offenses for the next 3 months?
Yes, sir.
All right. I'll delay sentence for 3 months. Don't commit any crimes. I'm not even going to give you any court costs. You lost enough money on this, brother.
Thank you. I appreciate that.
You probably missed a show or two too. So.
Yep.
Lesson learned. Have a great day.
Yes, sir. You as well. Thank you.
And you got some good stories to tell.
Yeah, I got the shit put to me by all the lumberjacks.
Oh, I bet you did.
Yeah.
Well, the good news is nobody else is going to make that mistake either.
Oh, yep, that's true.
Yeah.
Yep.
All right. Have a good day.
Mr. Andrews, before you or after you're done with your other guy, Mr. Geyer, can you pull Lee Madeira? She's in the waiting room. It's they're in the Wayne County Jail, so we can hurry up and get that one taken care of.
Okay, Lee Madeira, not a problem.
Yeah, thank you.
Thank you.
Judge, can you call BDEIWI, please?
Yeah, I'm here.
Hassan, is it Dewey? How do you say the last name?
Hassan Bidewi.
Bidiri. Good morning, sir.
Good morning, sir.
Good morning, Your Honor. Leslie Knapp, P 34696, appearing on behalf of the defendant Hassan Bidewi. Your Honor, I have spoken to Mr. Bidewi. I'm finding it somewhat hard to communicate with him because English is not his first language. Arabic is, and I think his interest would be better served by having an Arabic interpreter here.
Okay. All right, Mr. Badiri, we're going to adjourn this date until we get an Arabic interpreter.
Okay.
I have either September 28th, Leslie, or October 8th. Both will be back on Zoom.
I'm sorry. October 8th, that would be perfect.
Okay, that's going to be with Judge Martin at 9:20.
Okay.
Okay.
Okay. Mr. Vidivi, you'll get something in writing from the court, assuming they have your current address on North Silvery Lane. And that will tell you which judge and how to zoom in, okay?
All right.
Thank you.
Thank you. I appreciate that.
Okay,
Okay, bye.
you're free to go.
Thank you. Bye.
Okay, I'm confused why that one was on Zoom. He only lives in Dearborn.
Oh, see, I've got a New York address in our file.
Oh, she just changed it.
Oh, he did live in New York and he moved here, which is.
That's probably why.
from what
Okay,
I
well,
can
I guess
is
we'll
the
keep it on
problem.
Zoom. Alrighty, thank you. Judge, we can do right, and then Mr. Borea's Skipalis will be next.
Madam Clerk, before we handle right, I had sent you a chat. I don't think you saw it for me to speak to her one last time in a breakout before we
Oh,
go on
nope,
the
I
record.
did not. I'm sorry. I'll throw you in now.
It's okay,
Sorry
thank
about that.
you.
Yep.
I'm ready when you are, counsel.
On mine.
Are you ready, Mr. Borea?
Yeah, I'm ready. I'm ready. So on Ms. Skipalis, Avery, if you could unmute and turn on your screen. There we go. For the record, I'm Aaron Borea on behalf of Ms. Skipalis. Ms. Skipalis, please state your name.
Avery Nicole Skipalis.
Good morning.
And Your Honor, on this case, she's going to be pleading responsible to the civil infraction for double parking. The fine, I was told, would be set at $400 on this one.
Double parking, 400?
Yes.
All right, ma'am, is that the way you want to resolve this today?
Yes.
I will accept your plea to the double parking. Fines that cost $400. Can you pay that within 5 days online?
Yes.
All right, take care of that. The misdemeanor is dismissed. Enjoy your day.
You as well. Thank you.
Thank you. Thank you, Ms. Borea.
Thank you. Have a good one.
You as well.
Alrighty, friends, approaching the final half hour now of TCF Live. Let's go back to Texas and Judge Boyd.
I think the state is recommending deferred on this.
I think Judge Angelini was here and he preferred a PSI rather than make a decision.
All right. Court is calling 2026 CR 005187 and 2026 CR 005189 State versus Carla Hernandez. Could I have parties announced for the record?
Roger Pettis for Carla Hernandez, Your Honor.
And are you Carla Hernandez?
Yes, ma'am.
All right. You entered a plea of no contest in each of these cause numbers. According to your plea bargain agreement. And the cause number ending in 89, state is recommending deferred adjudication. This is running concurrent with 2026 CR 005187. They're taking in consideration 2026 CR 005191, and there's a $1,500 fine. And the cause number ending in 87. It's a $1,500 fine. State recommends deferred adjudication. And again, they're taking in consideration the same cause numbers. All right, so have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections to the PSI report from either side?
No, Your Honor.
All right, any witnesses from the state?
No, Judge.
Any witnesses from the defense?
No, Your Honor.
All right, I have some questions. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Carla Hernandez.
All right. So here's the thing. One, you've reached an agreement with the state. I'm inclined to accept your agreement. However, you need to be honest with me. All right, first thing, if you're drug tested today, what are the results going to be?
Probably negative, but I'm not too sure. I'm already clean from the marijuana.
When's the last time you used?
It was like 3 weeks ago.
All right. Do you have children?
Yes, ma'am.
Do they live with you?
Yes, ma'am.
And you're using like 3 weeks ago?
No. Like I stopped, but I mean, I'm going by like last month. Maybe probably more than 3 weeks.
Well, I mean, again, you have children and you're saying you used 3 weeks ago.
Like, no. Like I stopped. So, I mean, it's been like 3-4, like, I'm not too sure.
When's the last time you used?
I used the last month, like when I went to the probation thing.
That would be July.
Yes.
All right, so you used and you have children. What are your children's ages?
I have a 20-year-old, a 14-year-old, 8 and 4 and 5.
And do they live with you?
Yes, ma'am, they are.
And who else lives in the household?
Just me and my oldest son.
Are you employed?
Yes, ma'am.
What do you do?
I work at the San Antonio State Sales.
I'm sorry?
San Antonio State Sales.
And what do you do there?
I help get the house ready whenever my boss is gonna have the sale. And I price items for her. And I work the sales.
And talk to me about this hindering the apprehension or prosecution of a known felon. What's that about?
That's one of my fathers, it's my baby's dad to one of my kids. I was giving him a ride and
If I may judge, she was called by him and says, "Hey, I have your child support money, but I can't get to you. Come pick me up."
Mm-hmm.
So she's going there prepared to receive the funds, and she said, "Oh, I don't have them, but here, drive me to where I'm going to go get the money for you." And then that's when this whole fiasco occurred.
And then how does that turn into you're going to pick up child support, which I understand. Somebody says, "Hey, I have child support. You need it. You're going to go pick it up." How does that turn into your speeding at 100 miles per hour?
He threatened me to hit me, beat me up if I stopped because he didn't want, he had a warrant, I guess. So I was fearing for my life, and because we had a domestic violence in the past, so it was, I was scared. And then I just told him I'll just stop.
Well,
A further enhancement to the story is when they finally stopped, he ran across IH-10.
well, you know what? I will tell you this. So many people in San Antonio run across the freeway. I have no idea why they think that's a pedestrian way, but they do it. So here's my question. If all of this is true, then hindering arrest, apprehension, or prosecution of a known felon, if somebody is threatening you, then why are we here on that? Evading arrest, detention with a vehicle. If somebody threatening you, then why are we here with these charges? Because isn't that a defense?
Potentially it could be. There was just some distance that went on before the stop occurred.
But I mean, if somebody is threatening you, then is that not a defense? Am I wrong? I mean, if y'all want to continue with this plea, I'll accept this plea, but it appears that that would be a defense to evading. That would be a defense to hindering apprehension, prosecution.
We just thought under the circumstance, it would be best. She realizes the circumstances. Because the defense is certainly a defense, but that doesn't mean it's going to be accepted by 12 people.
I mean, I hear what you're saying. Do you want me to go along with this plea?
Yes.
Okay. State, any objection to the court following this plea? All right. Anything you wish to add, State? All right, thank you, State. All right, so we're going to start in cause number 2026 CR 005189. This is what the court will do. Probation, are you ready? Yes. All right, in that cause number, the court is going to sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person. Regular UAs. I'm going to follow the recommendation from the TAP evaluation. So there's to be intensive outpatient treatment with probation, proof of employment within 45 days, no employment as a home health care provider or with minors, no possession of firearms. I'm sorry, let's not do the no possession of firearms. It appears that she may have some issues with fathers of her children. This is run concurrent with 2026 CR 005189. Taking consideration 2026 CR 005191. There's to be no fine. Any objections to the court imposing no fine? I know your agreement was for a $1,500 fine. Any objections?
No objections.
All right, so there's going to be no fine, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. I'm going to order probation. Do you recommend MRT or just the cognitive course?
MRT.
All right. MRT, once that's completed, the remaining 100 hours will be deemed satisfied. Field visits 1 time per month for 4 months. There's to be no contact with Simon Jesus Eufracio, EUFRACIO. Probation, is there anything else?
No, Your Honor.
And I'm so sorry. You're going to have to provide no driving without proof of insurance liability and a valid driver's license. And I'm asking for that because I don't know what happened as a result of you evading at 100 miles per hour. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because that's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Thank you, ma'am.
All right, you're welcome. All right, we're going to proceed in 2026 CR 005187. And that cause number, the court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, intensive outpatient treatment with probation, proof of employment within 45 days, no employment as a home health care provider with minors. This is to run concurrently with 2026 CR 005189. Taking consideration 2026 CR 005191. There's to be no fine. Any objections to there being no fine, counsel?
Absolutely not, Your Honor.
200 hours community service restitution. I'm going to order parenting classes in the MRT. Once those are completed, the community service hours were deemed satisfied. There's to be no contact with Simon Jesus Eufracio. No driving without proof of insurance liability and a valid license. Probation, is there anything else?
Oh, yeah.
And probation with regards to the UAs, if you will make sure that she is tested for levels. All right, is there anything else that you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it? Here you go, counsel.
Yes, ma'am.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, the case that was taken in consideration, did y'all hear that?
You've already signed it, Your Honor.
Ah, all right, thank you. All right, good luck to you. Thank you, ma'am. You're welcome.
Alrighty, friends, now in the final half hour of TCF Live, let's do this. Let's go back to Georgia and check back in with Judge Manning.
3-8.
Your Honor, Anthony Pete for Mr. Henderson. He is a public defender client.
All right. Wow.
No new arrests, added on since 6/30/25.
Go, Ms. Jenkins.
Obviously, Your Honor, given the charges, given what we have in this case, and prior to any adjudication in this matter, the state would object to the removal of the ankle monitor until this matter is resolved either by plea or trial.
Judge, basically, this is an ankle monitor that was due to come off on June 22nd. Your Honor, extended it. Mr. Carter, his attorney, was actually here the last time, and I may have been here the time before that. Judge, Mr. Henderson is in a bind because he has family members who are ill. He has 3 aunts that are terminally ill. One lives in Alabama, one lives in Florida, one lives in Mississippi. He recently lost his father, which is how he got a bond to begin with. He would like to be off the ankle monitor so that he can see them before they pass away and make arrangements to get work so that he can pay for people to sit with them. This has been a long time coming, trying to get this off the ankle monitor. He has not been having any issues with the ankle monitor. He does what he's supposed to do. We would ask that the court release him from the ankle monitor and continue him on bond.
And now if he goes out of state right now, he's supposed to notify prior to the out-of-state travel. Who you suggest he notifies if he doesn't?
Judge, he would notify the bonding company and also would notify his attorney in the state.
Okay. All right, we'll remove it.
Thank you, Your Honor.
But make sure, so you go out of state. Okay, you gotta let them know. All right. Thank you, sir. Have a good weekend. Let's see. I'm in a good week. Geez. Number 4 is Wayne Davis, 26 PI 000425. Pre-trial.
122/26, no new arrests.
All right, second chance.
No known violations.
All right. Go ahead, Mr. Pete.
Judge, the calendar indicates this was due for removal in June. I was not here at the July 20th. I was out of town. My understanding that he was being brought back with an understanding if he had no violations that he had an opportunity to have his ankle monitor removed. We would ask for that.
All right, Mr. Jenkins.
Your Honor, in this case, we'll leave it at the discretion of the court in connection with certainly the allegations are serious. There is no particular, other than the state and society, connection with the actual victim of this matter. So you want to remove it, Judge? Go ahead.
Was there a arrest prior to this? Let's see.
And Judge, while she's looking that up, Mr. Davis notifies me that he is still in rehab. And I do recall that from the last time when I was here back in June, that he'd been in rehab. So there's a place that he's going to be. He's not allowed to leave.
So it's obviously inpatient. All right.
I guess technically it's not inpatient. It is a restricted move. He's off the drugs. He's not in a thing, but it's a thing where he cannot leave because that's part of the program.
It's an ITP, it's an intense treatment program.
Yeah.
So he's got to stay unless it's proved to go wherever, right?
That's correct.
For this arrest was in earlier. Was in 2025 for meth and drug-related objects. He pled in June on that case. 1 years confinement, 2 years probation out of foresight. And before that, his arrest was in 2017 10 years. So matter of fact, oh, he's still on probation, of course, so that case he committed with the intent for 10 years.
All right. All right, so we'll go ahead and remove it. All right, thanks, sir. All right,
Yes. Just have a seat over.
Yeah, this, that one, Davion Brown. So I see Mr. F isn't here.
No, I hired new counsel, Michael Bixon, but he had a conflict today as well.
Michael who?
Bixon. Bixon.
Okay. Guess we need to reset it then, don't we? Katara? Yeah. Because I didn't see an entry of appearance filed by him. When did you hire him?
Last Tuesday. He said he filed it in.
Let's see. Oh, there it is now.
Well, I didn't sign the contract. They'll talk out the hospital on Friday. So maybe that's probably why.
Yeah, it's in there now. All right, so we'll set you back out for the 21st September, okay?
Thank you.
Thanks. Whatever you want to do with that, Qatar, just extend it. October, we'll hear it then. All right, number 6, Davion Armstrong, 2507921. Davion Armstrong. No answer, Mr. Jenkins.
Yes, Your Honor. Subject to proper notice, Your Honor. State request bench warrant, bond forward.
All right. Let's see. You got Micah Wiley, number 7, 26 SC 001667. Is this one? Where is your attorney?
She said she had another trial to attend.
How about you remind her next time she files a conflict? I don't have anything right now. She's filing nothing. So where's the trial at?
She said it was at 1B, if I'm not mistaken. I had emailed her this.
So it's here? Mm-hmm. Why don't you go ahead and walk on over there and see if she's here, okay? And just come back and let us know. All right, let's see. 8, number 9, Marcus Smith, 25 PI 101037. But where is Miss Taylor? Mr. Smith, do you know?
I thought she was retiring.
No, Miss Drake.
I did too. Now you got who?
Miss Drake.
Drake. Oh, when did she? I thought she was retiring too.
Tracy Drake. She said she wasn't. She had another trial in another county.
Saying you got Tracy Drake now?
Yes.
And where did she say she was?
She had another trial in another county. She said she wasn't going to be here. She just wanted me to show up.
Well, you got 2 cases to see. 25 PI 010372. Let's see. Crazy. Does nobody know how to file a conflict?
I'm not gonna be here.
Huh? A conflict didn't tell their client to tell us they're not here. All right, so we'll reset you back out to September 21st. And we'll go ahead and extend this ankle monitor to like what? October, something like that?
I thought it was due off on the 11th.
Well, it is, but you ain't got no lawyer, but you're doing a great job arguing. All right, have a good day.
What date again?
September 21st.
Okay.
All right, let's see. Number 11, 26 PI 001131, James Doss. All right.
Judge, in regards to Mr. Doss, he has a hold as Decatur for forgery. No new arrest, been out to 12/26.
All right.
Hold for forgery out of Decatur.
There's a hold now?
Yes.
Oh,
What degree?
What day or when was that whole issue?
I gave him the paperwork. In a second.
Ms. Jenkins, you have him sit over there? You have him sit in the jury box so we figure it out?
Yeah, that would be appropriate, Your Honor.
All right. So we'll come back to that one, okay?
Yes, Judge. And
Okay.
I was curious to know what forgery, was it a misdemeanor or a felony? What degree of forgery, if it's known?
Doesn't say the level is from 2/12/26 out of the case.
Okay, thank you.
Let's see. One second. Let's see, number 12, Sharquinia S. Stanley, 26 PI 001486.
Which one, Judge? Stanley, 26, did you get it? Oh, yeah, there she is, sorry. 2/6/26, no new arrest.
All right. Take a chance.
No known violations since the last compliance hearing.
All right, go ahead, Ms. Jenkins.
Thank you, Judge. States will be objecting to the removal, Your Honor. Our victim is still, we had talked with her, still in fear of her safety, does not want the ankle monitor removed. And I believe that the victim in this case has moved her residence as a result of this incident. So that's the state's position at this time, Your Honor.
You said the victim's moved?
Correct, Your Honor.
Do you have any idea when you're going to indict this?
I will check with E.D. Hutchinson, Your Honor, in connection with the timing of that.
What's the history on this, Bostic? Bostic, you knew that was coming. Well, I'm just.
I get it. Pull it up.
Yeah.
I had pulled them up, but I only looked at the last rest, not the whole thing. And so a DUI in 22. And in New York, there is a prior, but it's over 10 years. Prior arrest for harassment. Harassment, second degree alarm or serious annoying, but that's in 2015. Sorry. Out of New York.
Let's see. Is there do you have a TPO against you? From here? From here in Fulton County?
I think it was like when I originally got arrested, I assumed that, because they was like, stay away, so.
Oh, yeah, okay, so you don't have a protective order.
Right, it's just a condition of her bond is my understanding.
All right, we'll go ahead and remove it.
Thank you, Judge.
All right. All right, let's see, number 13, James Weekland.
Julie, thank you for the $5. You say thank you for my Manning fix. You're welcome. With the few minutes that we have remaining, I think we'll just finish our day with Judge Manning.
Weekland, no new arrests, 7/26. Well, how are you?
Say it one more time. Look over here at me.
2/27/26, no new arrests.
All right, let's see. Take a chance.
No known violations since the last compliance hearing.
You want to hear from the state first? You want to go ahead?
Sure, Your Honor.
Go ahead, Ms. Jenkins, what you got?
Yeah, at this time, let's see here. Fortunately, we weren't able to have contact with this victim in this case, whether we left messages. in this matter, Judge. As our general position, certainly counsel to remove, the state does not. And I'll let the floor for counsel to speak on her final position at this time.
Thank you. Mr. Weekland has been, as you know, on an ankle monitor for 6 months at this point. I think he's due to be off in September, like the very beginning of September, something like that. 2 days, in 2 days. He has, this altercation involved two friends. Both actually were arrested. The complaining witness was arrested as well and has a pending pre-indictment matter. I was unable to determine if he had been actually indicted at this particular point, but he at least was arrested and charged in this
What's
case
his
as
name?
well. His name is Donald Cody Moore.
All right, go ahead. I'm listening. I'll see.
What's that?
I'll see. Let's see. Go ahead.
Okay. And he has, he's been compliant. He works in landscape, so the ankle monitor is particularly uncomfortable for him, doing physical labor every day in the heat that we've had this summer. And of course, we would ask that it be taken off. There's really no risk of him fleeing the jurisdiction. He's obviously been here. His wife, his family, his job, everything that he has is here.
What's Donald's middle name?
Cody, C-O-D-Y.
All right, let's see. Sorry. So so it looks like he was stabbed with a straight blade. What's his previous history? Pre-trial?
Judge, he has an open misdemeanor, CWAC, 2726, misdemeanor possession.
To this case, Judge. The misdemeanor has been accused, but the.
Out of Milton.
Yes, both cases are out of
And,
Milton.
misdemeanor. No felonies, just misdemeanors.
I think those are very old misdemeanors, with the exception of the most recent one as well, when he was like a teenager.
Steve, what we'll do, we'll move it on like September 21st, as long as there's no violations. Okay, now to give him time to notify the victim. So it's just.
Can he have contact with the victim with pending charges?
Mm-mm. Yeah, I guess.
No, I meant the state.
Can the state have contact with the victim?
Because he has pending charges.
Yeah, he doesn't talk to him about his charges. He just asked if he's scared of the guy that allegedly stabbed him.
Well, he's got a pending charge that he has an attorney. So I don't know if you can speak with him or not, but I'm just throwing that out there.
I got you. Why are you bringing it up? You know, this counsel knows what he's doing, so.
Okay.
So, but I mean, I guess if he contacts him, he'd call them and let them know, or let his attorney, but they'll figure it out.
Absolutely, Judge.
All right. So we can come back on the 21st?
And unless if there's no violations, then we'll take it off, okay?
Okay, I just want to confirm, we need to come back, or we do not need to come back on the 21st?
No, just come back. Remind me, we'll take you first.
Okay, 21st, got it. Thank you.
All right. Good seeing you.
You too.
Let's see, number 14, 26 SC 001150. It's Decorio Lovett. Decorio Lovett.
Remove his monitor. Can we remove his monitor?
Oh, yeah. Hey, Sarge, can they take off, can they take that commander off real quick?
Okay. You can take that.
Can she come back there?
Yeah, she can. That was it.
Thank you.
All right. Let's see. All right, so,
It also has a whole probation violation out of Marietta from 3/19/26.
have a seat in the jury box.
Where's the hold out of?
Probation violation.
Marietta. All right, let's see, Patrick Connolly, 26 SC 000
No new arrests to 2026.
All right, let's take a chance.
No violations since the last compliance hearing.
All right. Good, Mr. Jenkins.
Yes, Your Honor. State would object to the removal. We have spoken to the victim. Victim does not want the ankle monitor removed at this time. And she is still in fear of her safety pending the disposition of these allegations, Your Honor, that have been indicted.
Go ahead, counsel. I'm looking at it while you.
All right, good morning, Your Honor.
Good morning.
Donald McKinnon here on behalf of Mr. Connolly. At this time, Your Honor, my client has been on the ankle monitor for a little over 8 months. This is our second time appearing before Your Honor on this matter. He hasn't had any violations, and I would venture to say that the victim's fear is unfounded. My client is employed in sales in a supervisory role, and so you can only imagine the appearance of an ankle monitor during his course of work. He also is solely concentrated on raising his 16-year-old daughter, of whom he has primary physical custody. He hasn't had any violations. He doesn't desire to have any contact with the alleged victim, and also part of his bond conditions, there's a no contact order or condition as well. So therefore, respectfully, Your Honor, we ask at this time that he be eligible to have his ankle monitor removed.
He's had it on since
the end of January.
Oh, okay. Maybe what? Oh, it was extended through February 2027.
I didn't know anything about that. We appeared last time and they advised us that we were premature, and so we were set back on Your Honor's calendar for today. My office hadn't received anything about any extension.
Oh, let me see.
Or the basis thereof.
Oh, there's also a TPO in place, yeah. Yeah, I guess for some reason I did it. I was probably the victim then too. I don't think you were here, so yeah, another 6 months. Was assigned then. Do we have a date for them? Yeah. Okay. We just got it through the end of the year, so.
And that was nothing was advised by my office and during our last appearance either pertaining to that. We were advised we were just simply premature when we appeared. I believe it was in July when we appeared, and advised to be put back on this calendar to make such request.
I'd have to go back and look at my thing. So you want us to put you on at the end of the year?
I'd like to have it removed today if possible.
We'll take yours off you.
I'm sorry.
We'll take one off if you got one on, but yeah.
Oh, no.
Exactly. But yeah, so we'll put back on in like November.
Okay.
Because I think your TPO is still in place until, I think you came in front of me, I think, for the TPO. Yeah, okay.
That was when he was in custody prior to me entering the case?
I think so. Yeah, put him back like November, okay?
Okay.
November what's our date? Ms. Bard, sorry. There it is.
November date, November 16th.
November 16th.
9 a.m.?
Yes, ma'am. 9:30.
Okay.
And most likely to be in the same courtroom.
Okay. And may I ask, just for clarification purposes, is the reason why is because the imposed TPO condition?
Well, and I think there was no contact, there was contact with the victim that said she didn't want it, they didn't want it taken off.
But that's gonna be every case.
Well, but the ag assault's a little different, yeah.
Okay. Despite he hadn't had any violations?
None of he's been called on if he has, but yeah.
Okay, all right, thank you.
Okay. All right, let's see.
Alrighty, friends, that will do it for this morning, but fear not, because in about 2.5 hours, we will be back for second session at 2:30 p.m. Eastern, 11:30 a.m. Pacific, so do join us for that. I've got a pretty good lineup of stuff for you today. I'll also be back tomorrow for a full slate of programming. The pre-show, if you're a channel member, at 5:30, this show at 6. These are my times, so I guess it would be, 8:30 Eastern, and then 9 a.m. Eastern, and then second session after that, and sidebar after that, and basically I'm just going to turn on the camera and be on all day tomorrow, so it'll be good. But thank you for joining me, and I hope you all enjoyed the show today. The words of wisdom we leave you with from 1 Samuel Clemens, aka Mark Twain: do the right thing. It will gratify some people and astonish the rest. I find those to be very true words. Hope to see you all in a couple hours. Take care. God bless.